morning, guys. How is everybody today? I am good. I hope everybody else is good. My name's Debbie. Welcome to my channel. We are watching the Grant Amato trial. We have finished the first part of the trial. He has been found guilty, and now we are on the penalty phase. And after we get done with the penalty phase, if we have time, we're going to start Murdaugh today. If we don't have time, we will start Friday because I will be out of town tomorrow. Good morning, Jill, Judy, Jennifer. In August 2019, Grant's attorneys filed to appeal his convictions and life sentences. An appellate court affirmed the original decision in May 2021, denying Grant's appeal. After finally admitting to unaliving his family, he claimed he buried the pew-pew in the backyard of an old school friend. After multiple searches of many areas, officials have not been able to find the pew-pew. So, I really wanted to do the Mackenzie Shirilla trial, but it was not completely broadcast, and I'm assuming that's because she was a minor at the time. She turned 18 while she was in the hospital. So during the trial, she was not a minor, but I'm thinking maybe some of the people that testified were, because of her age, and they were like high school friends and whatever. I don't know. Anyway, it's kind of funny that when Wiggles told me about the case, it coincided with the time that The Crash came out on Netflix. Unless that's why Wiggles told me about the case. I don't know. I don't know if it's a coincidence or not. Anyway, Peter Tragos did a live yesterday on the documentary The Crash. So check it out. It's really good. He agrees with the judge. The points that I made about, I don't know if I told you guys about that. I've not listened to all the jail phone calls yet. Yeah. When he started off, I thought, these are the kind of cases that he takes. Car crashes and stuff. And when he started off, I thought he was going to be pro Mackenzie. And I was like, oh, I'm not going to like this. And then as he kept going, I was like, oh, no. He's on the right side of this. That girl. Oh my God. I know. And now he's saying his words were taken out of context. That if he had known that she was smoking pot and driving, he would not have wanted her to do that. But I was telling Travis, I don't know if I told you guys, she claims to have POTS, which I don't know what the letters stand for. I should know. Peripheral orthostatic. I don't remember what they stand for. But it's a disorder where when you stand up from a sitting position, your blood pressure doesn't acclimate as quickly as it should, and you pass out. That's all POTS is. And it has absolutely nothing to do with driving. Her mom and she both said, oh, I can just change positions sometimes and it'll happen. No, that is not how POTS works. So thank you, Judy. I've forgotten so much, y'all. I swear. I haven't been a nurse since 2010 and I have forgotten so much. I have not been a nurse 1 year shy of how long I was a nurse now. Postural orthostatic tachycardia syndrome. Thank you. So, if you were to pass out while you're driving, your foot is not going to go heavy on the pedal. You're going to go limp. You're not, and the road was an S curve road. You're going to veer off the curve. You're not going to be able to hold it steady when you're passed out. So, and Marty's here? Why don't I see Marty? Hi, Marty. I don't see you, but everybody else does, so. So that doesn't make any sense at all. And Peter said the same thing. He goes, if you pass out, how does your foot go down on the pedal? That's not logical. And I was like, oh, somebody else that gets it. Because it's not logical. If you pass out, you go limp, your foot's not going to go down on the pedal. Oh, he sent sparkles. I don't even see. Oh, that's right. I can't see that on StreamYard. That's why I can't see them. StreamYard needs to get on that. I can't see. I can see super chats and I can see stickers, but I can't see the new little thing with the gems. They'll get on that soon, I'm sure, because they like to change stuff. So, thank you for the sparkles, though, Marty. So, and then somebody because it was a live, but I was with you guys during the live, so I was on replay crew, and somebody said POTS has nothing to do with driving. It only happens when you stand up from a sitting position. And then Peter, and I don't know why he said this, Peter said, well, that could be true. I don't know. I'm not a doctor. And then the person that sent the super chat saying what POTS was sent another super chat that said, well, I am. Like, why would you say that, Peter? Nobody would lie and make up. I mean, I don't think he thought they lied, but like, I think he was, chat can sometimes throw out something they don't know the whole truth about. I guess he was doing that to like make sure he wasn't giving wrong information or whatever. But yeah, POTS on, and if I'd been in the live, I would have thrown my 2 cents in too, because POTS does not happen. Like, you're not just sitting and then all of a sudden pass out in your chair. Like, that's not POTS. So, and then I think in the clips from the trial that I did see, the prosecutor was like, you knew she had that and you let her go get a driver's license. I don't even know if that's on the list of things that you can't get a driver's license, because it only happens when you stand up and you don't drive a car standing up. So, but anyways, if you haven't seen the crash, go watch it. And if you haven't seen, you don't really have to watch the crash to watch Peter's video, but watch Peter's video too, because he said something about bench trial, because I was like, why would you choose a bench trial? But he said, in that situation, a bench trial is good. Because, hey, John, because he said that a jury would have hated Mackenzie. They would have hated her. So when it's a situation like that, where it's a very tragic thing that happened, that sometimes a judge will go easy, whereas a jury won't. So he was not surprised at all that they did a bench trial, and that actually he was more surprised that the judge was so strict with her, because usually in those situations the judge is not as strict. Hey, a werewolf. So I've got some really good clips. I started doing the clips so everybody could get in before we started doing the trial, because it seems like you guys kind of filter in one at a time. So the first one we have is Judge Weber, which I've not seen her in a while. Probably just because I haven't been watching judge stuff lately. I know you're unfiltered, Marty. You're always unfiltered. Now, this girl's a nursing assistant. I don't like that. I don't like mouthy nursing assistants. These are the people that worked under me when I was a nurse, and I would write them up over and over and over again, and my boss would throw them away because it's complicated.
When this nursing assistant with a habitual violator record got mouthy over a $200 fine, the judge went nose to nose and showed her how much worse it could get.
Ms. Contreras, how do you plead then to count 1, driving after being declared an habitual violator?
Guilty.
I will accept your plea and find you guilty. Where do you work, Ms. Contreras?
Wichita.
Okay, what kind of work do you do there in Wichita?
CNA.
At this time, I will sentence you to 6 months in the Butler County Jail. I will grant you a 1-year reporting probation, and as long as you're successful on that, you will not have to serve the 6 months. Do not violate any law during this 12 months and get the $558 paid. How much time do you need to pay that, if any?
I have a question. Why do I have to pay $200 for a Zoom meeting?
Well, you have to pay a $200 fine?
Yeah, why do I have to pay a $200 for a fine?
Well, I could give you a $2,500 fine.
Oh man, but okay, that's fine.
Fine can be anywhere up to $2,500. Your status is an habitual violator. That means you have been convicted so many times in traffic A and B misdemeanors that you qualify for revocation of license for 3 years.
Okay.
All right. Any more questions about that?
Nope.
Okay.
Oh, I do have one more question. Is it supervised probation or is it unsupervised probation?
Well, the recommendations of the parties was 1 year, but I'm starting to get concerned about your attitude and wondering if you need supervised.
Judge, I would prefer a breakout room with my client if I could.
I'll give you just about a minute, your client.
That's all I need, Judge.
That's all he needs to say. Shut up. Don't say one more word. Not one more word.
Thank you.
Thank you. Ms. Contreras, are you ready to proceed?
Yes, ma'am.
I am willing to work with you on that payment schedule. Can you pay the whole $558 today, or do you need some time to pay?
No, ma'am.
So you'll need to make payments of about $100 a month and have that paid off in 6 months.
I understand.
I know you understand, but your attitude is still an issue that troubles me. You don't want to be back here before me or another judge on an issue to revoke probation. Make sure you comply with the 2 terms I've given you, $100 payments until paid in full.
I have never known a judge to set up a payment plan, but I understand what you're saying.
I'm transferring this to reporting probation. Go to the probation office down the hall and report. Due on the 21st of each month thereafter.
What's the whole point?
What's the whole point?
All right, never mind.
What's the whole point?
I'm talking to the officer.
The officer isn't your legal advisor. The whole point is to keep you out of jail. And if I have much more problem, I'm going to say, forget probation. Let's just take her into custody and take her to jail for 6 months. Deputy, don't be doing that. Don't be mean with her.
I was just writing down her fines and stuff.
I know you were trying to help her, Deputy. Where are you going?
I'm going down the street.
No, you're going down the hall to probation.
Yes, down the hall.
If you don't do that, and if you don't do what I told you to do, then you can go down to the street to the county jail. You don't have yourself in that big of a predicament, but you just keep making it worse with your attitude and your responses. So I'm going to let you go now before you get yourself in any worse trouble. But you better be respectful to the folks in the court services, a lot more respectful than you've been to court.
Understand.
When this this nursing assistant with
Okay, hang on a minute now. I was an LPN for 9 years. She is a CNA. CNAs are nursing assistants. LPNs are nurses. There's just RNs have more responsibility than LPNs, but LPNs are nurses. I, as an LPN, was in charge of a whole 120 bed facility. So LPNs are real nurses. Yeah, she does. And you know that in that breakout room, the lawyer was like, shut up. And she just kept talking. What's the point? And whoever, what's the point? What's the point? And this one, wait, do I know this judge? Which judge? No, I don't think I know this judge. No, I don't. But this little girl, she is gonna, if she does not change her ways, this one is gonna be in prison for the rest of her life.
No, I'm done.
when
Don't say that. No, I'm done. I snuck into my grandma's house. Don't say that. Don't say that. No, I'm done.
When this defendant threw her tantrum in court and nearly confessed to her own bond violation, the judge stopped her from incriminating herself into more trouble.
Is it Ms. Lauren Woodhead?
You gotta speak up, dude. Seriously. I'm not awake.
This is a case where we were trying to hope that you would get a mental health evaluation, but you haven't shown up for it at all yet.
No, I did, and I rightfully contacted them for anything.
Where was it?
Excuse me, I wasn't done talking on my part, ma'am.
But you said you did go, and I'm saying, where was it?
No, I didn't go because I was supposed to go to the office of my attorney, my lawyer, and I called right before. Like, I called the day before, and I also contacted the forensics department. They made it seem like they're just trying to frame me and set me up, man. It's the system, dude. People need to be fired, and it's ridiculous, man. For real.
Right now, the reason that you're in custody is from yesterday when you got arrested. It has to do with being at a property where you weren't supposed to be. The bond violation is for that. What are you doing right now for work? Are you working anywhere? Don't really want to talk. That's okay.
No, not necessarily, but then again, you're not giving me any time to talk, ridiculously enough. So I'm upset because I'm just now getting my life together as of yesterday, and that's when I get arrested. And it's just like, I don't even want to be here anymore, to be honest. So
Okay, I gotcha. The original charge is a 2-year felony, and that's not over. Now, this is a new charge of a bond violation. And a bond violation is alleging that you went to your grandma's house when you weren't supposed to. So we'll just say not guilty for you and let you talk further with your attorney to discuss what you want to discuss. I'm going to set the bond right now at a 5,000 10% bond and see if we can set up by Zoom the forensic eval. Don't have any contact, directly or indirectly, with your grandma.
that was very clear the day.
I don't think it was too clear since it was yesterday that you got arrested there.
Well, excuse me, I'm talking. We all have our turns to talk. I'm sorry, man. I don't really care at this point. I snuck into my grandma's house and
Don't say that. Don't say that.
Well,
You
because
don't
I
want to see
know
anyone.
what's been going on for months. I have nothing and nobody. Why are you looking at me like that? You look like a tweaker. Anyways,
Ms. Woodhead, I'm going to cut you off now because you're saying too much to incriminate yourself. And then all of a sudden
really
I got
not,
to give you
though.
jail time. When you say you snuck into your grandma's house, that's a confession right there.
No, I'm
Normally
done.
really nice.
Can let the court know that I attempted and tried to assist Ms. Woodhead in getting to both of her evaluations numerous times. Court was kind enough to allow, and the forensic center were both kind enough to allow Ms. Woodhead to do the evaluation via Zoom last Wednesday at my office. However, she did not appear, and that was due to no one else's fault but Ms. Woodhead.
I'm just setting the bond right now and we'll see if we can do the forensic eval by Zoom.
I snuck into my grandma's house and
Don't
Ms.
say
Woodhead,
that. Don't say
Ms.
that.
Woodhead, don't-
no.
I think she was talking to her lawyer. She gave 0 F's that she was in court. Excuse me, I was talking. We all get our own chances to talk. She just okay. This was good too. I don't know this judge either. but I really like her.
When this defendant refused to cooperate and tried to object to everything, the judge shut it down and revoked his Zoom privileges.
Are you Mr. Locke?
Object.
Sir, if this is the route it's going to go, and I think I've been very super fair to you with your bail and with all of those other things, if this is how it's going to go, then I will never allow you to be by Zoom again, and we can get a warrant and we can go that route. So if you want to cooperate and you want to participate and be nice to me as I am nice and respectful to you, we can go about it that way. How would you like to go about it?
I am trying to speak, and you are.
All right. So here's the
letting
thing.
me-
Nope. I'm letting you
I'm
speak,
not
and
trying-
you want to
I'm-
speak and
listen.
tell me all about your contract
Excuse
and
me.
how you're going to hold me
I'm
responsible.
not
all of those
contracting
things.
anybody. I'm not saying any
Okay,
of that.
well,
I'm just
then-
trying to speak my
So then tell me.
constitutional right. That's it.
On your birth certificate, did your parents name you Ryan Locke? And I did grant you leniency, Mr. Locke, to appear by video. I have every right to never allow that to happen ever. You understand that? Yes or no?
I'm asking you a question. Can I ask you a question?
Nope,
Yes
not
or no?
unless you answer my question. Do you understand what I said? Yes or no?
I object, and it sounds like the court is trying to get me into their jurisdiction.
All right, we will go on the
Is this
record
court
in the
in
matter
of record?
26 EF
Is this court of
46
record?
26 TR 306, State of Wisconsin versus Ryan
object.
Locke. Ryan Locke appears
Oh,
by
no,
video
Wisconsin.
conferencing. He did call and ask permission of the court. He was being a cooperating individual and a human being. However, he is failing to cooperate here today. Therefore, the court is stating on the record, at no time in the future, at any time whatsoever, Mr. Locke, may you appear by video conferencing or telephone. Your hearings will always be in person. With regards to today, the court will quash the warrant. I don't have to do that, but I'll be nice and I'll quash the warrant. I'm resetting it to another date and time, May 27th, 2:45. We shall see you then. I
speak?
strongly recommend that you call the public defender's office
muting me.
and you
Why
get
are you
another
muting-
attorney appointed to you. I'm resetting it. Thank
Can I
you very
speak,
much.
please?
We are adjourned.
Object.
Bye.
Can I ask you a question?
Nope,
Yes
not
or no?
unless you answer my question. Do you understand what I said? Yes or no?
Bye. Why are you muting me? I guess because she doesn't want you to speak. Really? Cool. That's going to be a conflict of interest, though, if he gets anybody that. Well, I guess they wouldn't put anybody that he arrested in front of Judge Middleton. Oh! He's Oh, excuse me. He's retiring. Oh. Wait. What are you guys talking about? Judge Middleton. Judge Middleton retires in July. Okay. Penalty phase day 1. Okay, so yesterday we watched the opening statements for the penalty phase. So this is going to be Chris Sisko, the guy that worked with Cody, Sloan Young, I think that was Cody's girlfriend, Jason Amato, which is Cody and Grant's brother, and Dr. Richard Carpenter. I don't know who that is.
Raise your right hand, be ready to be sworn.
Oh, you're talking with like people that like are all mouthy to the cops. and then their cases get dismissed. Yeah. Yeah. It makes me mad too. I don't understand that. My dad was a cop too, but I was raised to respect authority. And the way people talk to cops, I don't understand. I literally don't understand why people think they can treat authority like that. I literally don't understand it. Why do people think they can get pulled over and talk to a cop that way? It makes no sense, no logic at all to me. I don't understand it. Because to me, when you get pulled over by a cop, you're supposed to do what they tell you to do. Even if you weren't doing anything wrong, you have to, they pulled you over for a reason. You have to listen to whatever. I don't understand it. I just don't understand it.
Thank you, Your Honor. Good morning, Mr. Cisco. How are you?
Good morning.
I know that you've testified in the first part of this trial, but let me still ask you a couple of background questions so the jury gets reacquainted with who you are. So first, tell us what your name is.
Chris Cisco,
And where do you live, Mr. Cisco?
Orlando, Florida.
And what do you do for an occupation?
I'm a certified registered nurse anesthetist.
And tell the jury, what is that? What duties does that encompass?
So what we do as a provider of anesthesia, we just provide anesthesia for patients that are going to be put under for procedures or for surgeries.
Now, as you certainly indicated during the first part of the trial, you knew Cody Amato during his lifetime, but let me ask you to tell us again, how did you know Cody Amato? How long did you know him? Just describe your relationship with Cody Amato.
Sure. I knew Cody Amato for about 45 years. We went to anesthesia school together, graduated together, and then started our first job as CRNAs together. And I'd say we were both professionally friends, but outside of work, friends as well.
Tell the jury about Cody Amato. Just describe him. Tell the jury what Cody was like.
So as far as Cody's character, I think he had a lot of the qualities that you would want in a friend and a colleague. Reliable, dependable. You could always count on him to do the right thing. Very knowledgeable. And again, very compassionate with his patients. I'd say one of the best CRNAs that I've worked with.
And describe to the jury the impact upon your life and the community at the hospital. Describe to the jury the impact on your life and at the hospital, the effect of Cody's death.
I'd say as far as the hospital, I mean, it was a tremendous impact. I mean, Cody always had a positive attitude. From the beginning of a shift to the end, you could just feel his positive presence whenever you're with him. So he's definitely missed for sure. As far as for me, he's just a great friend. I mean, I just miss, seeing him in the morning and just having him at the hospital was, just a great asset to the team, a great team player. I knew that if I ever had, an emergency or a trauma, he was the guy that I wanted to be in there with me to give me a hand. He's just, we all really miss him. Every time I see people, we always talk about how we miss his positive attitude.
Thank you very much, Mrs. Sister.
Any cross?
No cross, Your Honor.
All right. Thank you very much, Mr. Cisco. You may step down and you're excused. Next witness.
The state calls Sloan Young.
Ms. Young, if you could come forward, raise your right hand, be ready to be sworn.
You solemnly swear or affirm that testimony you're about to give will be the complete truth, so help you God.
I do.
Could I have a seat? Just.
Good morning, Ms. Young. How are you? We know that you testified during the first part of the trial. Let me just ask you some questions just so you can be reacquainted with the jury. So first tell us, please, what is your name?
My name is Sloan Young.
And where do you live, Ms. Young?
I live in Osceola County, Florida.
Please tell the jury what do you do for an occupation?
I'm a licensed practical nurse at Orlando Regional Medical Center.
And briefly, tell the jury, please, what do your duties encompass as a licensed practical nurse?
I work in surgery and I work with anesthesia. My basic job is to be an extra set of hands for our nurse anesthetists if they need it.
Now, during the first part of this trial, we know that you knew Cody Amato during his lifetime, but let me kind of get a little bit deeper into that and ask you to please tell the jury, how did you know Cody? Describe how long you knew him, describe your relationship with him, please.
Well, we started off as coworkers. I started working at Orlando Regional in May of 2017, and we basically became friends as soon as we met. We bonded very quickly over just similar interests, sense of humor, and we became very good friends. And in the last couple of months of his life, we quietly started to date because we had feelings for one another.
I'm sorry, can you speak up a little bit?
I'm sorry. The last couple. I'm sorry.
There you go.
Okay.
Box right in front of you.
Okay.
That's the microphone.
Sorry. Thank you. The last couple of months of his life, we quietly started to date because we had feelings for one another.
Now, Ms. Young, tell the jury about Cody. Tell us what kind of person he was. Just describe him to the jury for us, please.
Cody was the best kind of person. He cared so much about his job and his patients, and not just them, but his coworkers and his friends and his family. Like, he had so much love in him for everybody. He treated everybody the exact same, with respect. He treated all his patients with the utmost care. He was the gold standard of CRNAs. People still say, when they graduate, the students say when they graduate school, they want to be like Cody, because he set that bar so high, not only as a nurse anesthetist, but as a human being. He was an amazing friend to all of us. He was the go-to guy if you had a medical question, or if you just wanted to vent about something that had happened in the OR, or if you just wanted to joke and laugh. He was that guy.
And finally, my last question is tell the jury how his loss, his death, has affected or impacted you and also the community at the hospital.
It's been devastating for all of us. It's difficult to accept that he was only 31 and he will never be any older. It's difficult for our coworkers to know that his light is no longer in the OR and in the operating room, And we joke that the morale in the operating room died with him, because it's just not the same. He's very missed by all of his friends.
Probably. That's what she meant.
He was an incredibly special person, not just to me, but to all of our friends. Excuse me.
Hospitals, everybody knows everybody else's business. It's like living in a small town.
It's very difficult to even put into words how not only I feel, but all of us, friends, family, coworkers, feel over his loss, because it's just It's just insane that he's not here. We all miss him very much. And it's very unfair that he is no longer with us. And it's very unfair that as we all grow and get older, he'll never get to see our friends start families, get married, have children. He won't get to see our friends go on in school. He'll never get to come to any of my graduations as I continue on school, and I'll never get to hear him tell me how proud he was of me for continuing on with my education. And even doing things like ordering Jimmy John's, which he loved Jimmy John's sandwiches. I miss just those little things about him.
That's a
And I
hospital
just miss
thing too.
entirely who he was
They
as a
deliver
person.
so fast.
And I'm very grateful and fortunate I got to have him in my life for even a little bit.
All right, thank you very much.
Questions, defense? Questions, Your Honor. All right, thank you very much. Thank you, ma'am. You may step down. State, you can call your next witness.
Your Honor, we would now like to present Jason Amato. I expect that he's going to be reading an impact statement.
Raise your right hand. Be ready to be sworn.
Solemnly swear and affirm that the testimony you're about to give will be the complete truth, so help you God. Yes.
I got one of the new ones the other day. I can't remember what it was though. It was good.
How are you?
Good
I
morning,
remember what
Mr.
it
Stone.
was.
Once again, we know that you testified in the first part of this trial, but just to kind of reacquaint the jury.
I don't
please
do
tell us
that.
your
I'm
name.
57
My
and
name
proud
is
of it.
Jason Amato.
And did you know Margaret, Chad, and Cody Amato during their lifetimes?
Yes, they were my mom, dad, and brother.
Because I almost didn't make it.
Is there? I see that you have a statement, piece of paper in your hand. Is there an impact statement that you'd like to read to the jury?
Yes.
Please do.
Okay. Where do I begin? This has not only affected my life and those close to me, but the ripple effect has been widespread. I cannot give an exact number of how many people have felt the loss in my family, but there were hundreds of people at their funeral. The minister that led the service told me in his 50 years, he has never seen a funeral with 3 caskets. It has been very hard to devote reflection to either my father, mother, or brother. As I start to think of one, it's hard to not think of the others. There are so many memories, stories, and special times that I will never forget. However, I will never be able to make new ones. My father was a great man that only wanted the best for his family, especially his boys. Dad's approach to anything in life could be a bit overboard, but he liked to know all the pros and cons of something as small as going to the grocery store or getting a big purchase like a car. I will never forget the life lessons my father taught me, and I will miss his advice. My mother had the best outlook on life. She always found the good in a situation. There were times I didn't know what to think or do, and my mom was always there to guide me. One of the biggest things I miss is being able to talk to my mom. It's been 208 days. Sorry. I really miss her voice. But I am a better person because of my mother, and I am forever grateful for that. All right, so my brother Cody, he barely had a chance to make a name for himself, and let me tell you, he would have made a big one. Cody was a very motivated and caring man that took great pride in his profession while keeping his exemplary character outside of work as well. There are so many people that I have met in some way were touched by my brother. I will miss him dearly. These are just small tidbits of my family members and does not encompass everything they were as my father, mother, and brother. Not only have I lost my family, but there are so many people that have felt it as well. It would take too much to go through all the different people, but it ranges from family, friends, coworkers, neighbors, and even strangers. There are so many people I did not know before January 25th, and it touches my heart that so many have been supportive through this. There are too many names to go down the list of those whose lives have been affected by this tragedy, but here are a couple. My grandmother, the mother of my father, still has trouble accepting she lost her firstborn. My dad, her best friend, my mom, and her grandson, Cody. My uncle Randy, brother of my mom, has told me so many childhood stories and that he hates he wasn't there to protect his sister. Lifelong friends of Cody, Blake, Jericho, Ryan, Marcos, Ken, Mo, just to name a few, tell me how much they respected Cody, and they have lost more than a friend. They lost a brother. The toughest thing in all this is how it continues to affect my girls, especially the kids. Christina misses the stories and comfort my family gave, particularly my mom, who always made her feel like a daughter. There are certain things Christina adored about my mom. She could light up a room with her smile and go with the flow personality. Our daughters, they're troubled daily. Nightmares, depression, confusion, fear, and having to live lives in the public eye. They miss the days at the barn with my mom, who taught them both how to ride. She taught them both how to ride horses. Also, our oldest daughter enjoys talking healthcare with Cody and my dad. This is what gave her a passion for the medical career. There are numerous occasions I can think of, but to get to the real question, or how this has affected me, plain and simple, 2019 has been a tragic year. Too many tragedies for anyone to handle, let alone the children. It's just so hard to go through the grieving process when there are multiple losses and uncertainty in the future. Through all this, though, I am a proud Amato, and I will rise up stronger and smarter than before. It's just going to take some time and hard work. My main focus is my girls and making sure they are healthy, physically and mentally, and that no one can hurt them. I cannot imagine losing any of them. I've already lost my mother, father, and brothers in a blink of an eye. Though they are gone, I want everyone to know Chad, Margaret, and Cody are amazing people that will live on forever. That's it.
I have no questions, Your Honor.
Thank you. You may step down.
Ooh, that was rough.
State, do you have any further witnesses? All right. So at
I'm
this
not
time,
crying. You're
the
crying.
state rests. Then the defense.
Mr. Amato, Jason, I am gonna need just for one thing.
Yes, sir.
I'm sorry, I
All right.
just need him to take the stand just briefly.
Mr. Amato, come back. Have a seat. You're still under oath, sir.
Seriously, what do you need to ask this man?
Jason, I know that we've met outside of the courtroom, but I just also want you to know that I'm very sorry for your loss. Back when we were preparing this case for trial, you have essentially been placed in charge of the home in Chuliota, correct?
Yes, I'm in charge of the estate, and the estate oversees the property.
Okay. And one of the requests that we made of you, which you graciously complied with, was you gave us photographs from Grant's childhood. Is that correct?
Yes, sir.
Okay. May I approach the witness, Your Honor? Mr. Amato is showing you a series of 16 photographs that are currently marked as Defendant's Exhibit B. I just ask you to real quick, at your own pace, just please go through those and to verify that those appear to be photographs or copies of photographs that you provided to us.
Yep. Looks like most of them, yes.
Okay, well, these aren't all.
Right, these are the ones, yes, those are ones that I provided.
Okay. And we returned the originals to you, correct?
Yes, sir.
Hey, Nancy.
At this time, we would move Defendant's Exhibit B into evidence.
No, Your Honor, no objection.
As Defendant's Exhibit B, Composite Exhibit B will be moved into evidence as Defendant's Exhibit 1 in evidence.
Last question, Mr. Amato. Despite everything that's happened and all the loss that you've suffered and everything, do you love your brother, Grant Amato?
Yes.
Okay. I have no other questions.
I have no questions, Your Honor.
Thank you very much, Mr. Amato. You can step down.
Defense will call Dr. Richard Carpenter.
Judge, I'm going to approach for a moment, please.
Crap, his neck is broken and I can't fix it. His neck is broken. Neck is broken.
If you could please come forward, Dr. Carpenter. Come forward, raise your right hand, be ready to be sworn.
You solemnly affirm that testimony you're about to give will be the complete truth, so help you God.
I do.
John,
You can have a seat, sir.
Feel like it with a broken neck.
Do you have it taken care of? Good morning. If you could please make sure and move your chair forward. The box that's in front of you is actually with the black, that's actually the microphone for the courtroom.
No
Okay,
problem.
not the one next to you. All right, you may proceed, Mr. Leichel.
Thank you, Your Honor. Dr. Carpenter, could you state your full name for the record?
Sure. It's Dr. Richard Carpenter.
And Dr. Carpenter, what is your occupation?
I'm a licensed psychologist.
Okay. Do you have any specific fields that you specialize in the field of psychology?
Well, I consider myself what is called a forensic psychology, which is an area of psychology that essentially is courtroom evaluations, courtroom testimony, that sort of thing.
How long have you been a licensed psychologist in the state of Florida?
I received my license to practice in 1984.
Okay, and you've practiced continually since then?
Yes.
Okay. Would you be able to give the ladies and gentlemen of the jury an idea of how many forensic evaluations that you've done over your career?
Well, what I generally testify is that I do probably 10 a week, 50 weeks. It's about 500 a year. And I have been a forensic psychologist since about 1988. So that's well over 15,000 evaluations.
Okay. And in the field of forensic evaluations in death penalty cases, can you tell the ladies and gentlemen of the jury what type of experience you have in that regard?
Sure. Well, a lot of what I do is what they call competency evaluations, which is to look at whether or not a person is competent or capable of proceeding in a judicial process. And I've probably evaluated well over 100 first-degree murder cases for competence. Thank you. I've done sentencing work as it relates to what we're doing today. Not a great deal, probably around under 10, I would guess, of those specific types. And then I've been up to death row in Rayford, doing what is called post-conviction appeal work for people who've actually been convicted of the death penalty and are appealing their convictions. So I've been up to the prison on, I would say, probably about 15 to 20 of those cases as well. So a whole host of first-degree murder-related cases.
Thank you. Now, were you specifically retained in this case to conduct a forensic evaluation of Grant Amato?
Yes.
And when and where did this evaluation of Grant Amato take place, Dr. Carpenter?
I saw him at the Seminole County Jail. Let me get the exact date. I believe it was July 9th, but let me take a look at my records so I give you that. Just bear with me for just a second here. July 9th of this year, 2019.
Okay. And prior to July 9th of this year, after I actually drove over to your office and met you before July 9th, did I not?
That's correct.
Okay. Did I bring some materials with me and get you up to speed as to what was going on in Mr. Amato's case?
Yes.
Okay. And have you had the benefit of reviewing any specific documents of Mr. Amato's past?
Well, basically, I had been provided a letter that he wrote to men in this chat room that he was involved in. The toxicology report that was related to a case of possible grand theft, which we can talk about. There was also a evaluation that was conducted pursuant to that case. The way it appeared was that the lawyer that he had retained for that case had asked for that evaluation to be done.
What type of evaluation was it that was done pursuant to that lawyer's request?
As best I can tell from looking at that evaluation, I would call it a fitness for duty evaluation, because the allegation was that there was some inappropriate behavior done while he was in the employ of a hospital. And what it looks to be the case from reading the report is that he was evaluated by a Dr. Cruz for his fitness to practice as a nurse.
Okay. So all this was related to him getting back to work after his arrest in June of 2018?
That's correct.
All right. Now, were you also, excuse me, items of evidence. You made reference to the 2018 arrest. Is that correct?
Yes.
All right.
I
You
don't think
also
so.
make reference to that arrest. What, to the best of your knowledge,
He was found guilty of using a gun, but not the theft of the gun.
what became of that arrest in Orange County, Florida?
Well, according to the document that I reviewed, which was attached to a letter from his attorney, it was what was concluded in Orange County was, and I'm quoting, this is from Catherine Marlowe, Assistant State Attorney, from the investigation which has been made, it is the opinion of the writer that this case is not suitable for prosecution.
Okay. And the title of that document is a no information notice. Is that correct?
That is correct.
All right. And were you also provided with a copy of a certified copy of a Florida Department of Law Enforcement criminal history background?
Yes.
Okay. Were you also provided a copy of a copy of the certified birth certificate for Grant Amato?
Yes.
All right. May I approach the witness, Your Honor? Doctor, all of these documents have been stipulated into evidence by the defense in the state of Florida. I asked you if you could first identify what is listed as Defense Exhibit C.
That's the no information notice that I just quoted from by Catherine Marlowe.
Okay. And what's been identified as Defense Exhibit E?
Yes, I've reviewed this. It's the FDLE criminal history, Florida criminal history on Grant Amato.
Defense Exhibit D.
That would be his birth certificate.
Noting that his date of birth is?
Date of birth, May 20, 1989.
And this is a composite exhibit, which is designated Defense Exhibit A for identification purposes. What records are contained in that particular composite exhibit?
This first one is educational records from elementary school. Further, Orange County Public School records.
That would be for high school?
Correct. These are his grades and so forth. His records from the University of Central Florida. His transcripts from the University of Central Florida. An essay that he authored for his application, which is requesting that he discuss some life event that he overcame and so forth. That's in there.
Okay.
Further records from UCF. This is all UCF. UCF. Yep, there's quite a bit of them there. Yeah, the rest of that is all UCF records. There's, in the next section is license to practice from the Florida Department of Health.
Does it reflect the date that Mr. Amato was first issued a license to practice as a registered nurse?
Original date 2/10 of 2012.
And to your knowledge, his license is still active as of today?
I would assume so.
Okay. Thank you, Doctor. Now, all of this information was utilized by you in conducting your forensic evaluation in this particular case?
That's correct.
Judge, I would, at this time, move defense exhibit A, composite exhibit into evidence.
Are you going to attempt for the others as well? C,
Yes,
D,
Your
E, or?
That would also be defendant exhibit C, the no information certified copy from Orange County.
D and E. So
D as a date, Your Honor.
and what's been pre-marked for ID is composite exhibit A will be moved into evidence as defendant's exhibit 2 in evidence. What's been pre-marked for ID is exhibit C and will be moved into evidence as exhibit 3 in evidence. What's been pre-marked for ID? Are you moving the birth certificate in?
Yes, I am, Your Honor. That
As
is
composite exhibit D will be moved into evidence as defense exhibit 4 in evidence. What's been pre-marked for ID as defense exhibit E will be moved into evidence as defendant's exhibit 5 in evidence.
Thank you, Your Honor. Now, approximately how long were you with Mr. Amato at the Seminole County Jail when you were conducting your forensic evaluation, Dr. Carpenter?
It was right at about 3 hours.
And as a result of your evaluation of Mr. Amato and the information that you gained from him that date, as well as the review of the historical documents that you have indicated that you're familiar with, were you able to reach a conclusion with regards to Mr. Amato and his ability or the idea of whether it would be appropriate and what the chances are of him committing any acts of violence or being a management problem if he were to be sentenced to life in prison without the possibility of parole? Did you reach a conclusion in regards to that?
I did.
And what was your conclusion, Dr. Carpenter?
It's my conclusion, based on all of the information that I obtained for this evaluation, that Mr. Amato's likelihood of future violence, should he be given life in prison, is very low, and that he's also very low, of a very low probability for any form of major acting out or management problems while incarcerated.
Now, did you have the benefit of, in reaching that conclusion, additionally, that during his time period in the Orange County Jail, that Mr. Amato's had no disciplinary referrals or has otherwise been a model prisoner while at the jail?
That's my impression. One of the things that tells us about future behavior is current and past behavior in any particular category. So one of the things that's very informative when we look at people's adjustment for being incarcerated is how have they done in the past in a similar environment. And by looking at how he's done, and this is his only time being incarcerated per se. There was a brief time when he was first arrested, I think, before he was out, before he was formally charged. I believe he's in for a few hours, but he has been in for several months since the beginning of this year. And during that time, I asked him if he had any disciplinary reports, or DRs as they're called, and he said that he had none.
Okay. And that was something that factored into your conclusion as well?
That's correct.
All right. Now, Dr. Carpenter, can you explain to the jury what a clinical forensic evaluation is in the context of a case such as this, when the only two possible sentences are life in prison without the possibility of parole or death?
Well, basically, the evaluation looks at the circumstance that he will be in should he be sentenced to life in prison. In predicting any kind of future violence, like, for example, if I'm asked to talk about someone going on probation, the environment that I would be looking at is what would they be like in the community. In this particular case, the context that I'm looking at is what would he be like should he be sent to prison for the remainder of his life. The second component of that is to look at the historical and personality factors of the person that I'm interviewing and evaluating, because as we know, behavior is really a combination or an interaction between circumstance and the personality or behavior patterns of the person under evaluation.
Okay. Now, did you prepare for the benefit of the jury a clinical forensic evaluation that we would be able to place up on the overhead?
Yes, I made up something that would help the jury understand the presentation, and we would
you like me to put that up at this
beyond.
time, Doctor? I forgot to give the doctor something, Your Honor. Can I approach him briefly? Thank you.
We also have the mouse there, if he wants to use that.
He's already been trained on the pointer.
All right, because otherwise we have communications.
Yes, please. Okay, is this the clinical forensic evaluation sheet that you prepared for your testimony here today, Dr. Carpenter?
Yes, I had suggested that a way to educate the jury about the factors that I was going to be discussing would be to provide some form of visual aid, and this was put together for their benefit.
Now, you mentioned previously violent behavior is an interaction between circumstance and personality. Can you?
Hang on. I found something I have to watch. It's 30 seconds long.
Galen, you should record this.
Okay. Sorry, I had to watch that.
Can you give us an explanation of what that means?
Well, quite simply, when people talk about behavior regarding any type of behavior, it's really a function of the circumstance and the personality or behavior pattern of the person. It's not merely the person that's in the circumstance, because circumstance can play a vital role or strong role on how a person behaves. Someone very timid under a certain circumstance, if his family or wife or what have you is being pushed on or what have you, that person might rise to the occasion and become quite heroic. So you have to look at what's the circumstance that sets the stage for the behavior.
Okay. And so what is the circumstance or context in regards to this particular case, that being prison?
Well, again, as I mentioned earlier, what we're trying to understand is how Mr. Amato might behave should he be sentenced to life in prison. How would he react? What is the likelihood of him being either violent or a major behavior problem for the institution?
Okay. And of course, then, it follows up there. It says, what do we know about violence and people serving life in prison?
Correct.
Okay.
And we have a overhead or a bar graph, which we can show at some point in the presentation.
Okay, well, now you've got a thing up there, example, teenage male drivers versus older female drivers. What's the context for
Right.
that?
So what I wanted to do today by putting in that example was looking at group data, which we're going to do when we talk about this particular category of inmate. This category would be the group of inmates who have been sentenced to life in prison. So what do we know about that group? And group data provides guidance for all kinds of decisions. I think the thing that I felt would be most informative for the jury was the way in which, on example number 4, when insurance companies set up the rates for car insurance, a teenage male driver, 16 years old, is going to pay way more money than an older female driver. And why is that? Well, because the two groups, when the insurance companies set up their billing schedules, they know that 16-year-old boys are likely to have far more accidents than middle-aged women. As a result, they're going to pay more than the female older drivers do. And that basically is a group analysis of which the person is a member of. In this particular case, what we're going to be talking about is what do we know about people who are in prison for life? What are they like as a group? And from there, we will then talk specifically about the individual under consideration, which is Mr. Amato.
And in that particular, in addition to the other factors that you've talked about here, you're also making reference to his age. Is that correct?
That's correct. That is one of the factors
Maybe I'll get you one of
that we
these.
will be looking at.
All right. Now, you've provided me with some
You want one of
graphs,
these?
to provide visual aids to the jury to understanding what you're talking about here today. Is that correct?
Correct.
Would it be helpful if I went ahead and put up the first one you and I talked about?
Yes, that would be good. So what you're looking at here is research done on the rates of violence per year for a group of different categories of inmates. The first one is death row. You see 1.6. The second one is the group that we're interested in, which is those individuals who've been sentenced to life.
Really?
The third bar, which is 11.6, is what you would call system-wide. That's general population, any kind of category of inmate. And the highest rate of violence is seen in the high security category. These are generally inmates who've already had frequent episodes of violent acting out or major forms of rule violation. The important point that I want to have you take away from this graph is how low the rate of violent behavior is in the group of men, typically men, it's almost 99% men, who were incarcerated under a life sentence. So much like I asked you to think about young teenage drivers and older female drivers, and to get a sense of how you would look at those groups, this bar that says life sentence tells you that as a group, this type of inmate is perhaps surprisingly low on a base rate of violence.
Look
And
on DisneyStore.com.
Just so the jury has a sense, these numbers that are reflected on this graph, this is per 100 inmates?
Correct.
Okay. And this is coming from data that you maintain in your practice as a forensic psychologist.
Well, this is research that has been published in a peer-reviewed journal. This is peer-reviewed journal data.
All right. Now, I've got a couple other graphs as well. Is there another one that you would like me to put up now?
Well, I would say if you would put back up Mr. Amato's, the one we were looking at earlier.
Yes, sir.
The clinical forensic evaluation, if you don't mind.
Give me a second to get it all back down to right size.
There you go. So we've already discussed number 5, and if you want to refresh your memory, it's up there for you to take another look at it. I know we're going to go over a lot of things here this morning. So as I just pointed out in number 5, their rates are quite low when compared with high security and general population. One of the things that's worth also pointing out is that on number 6, I wanted to bring to your attention that half of the individuals in that study were individuals who have been convicted of murder. So if you're thinking, well, wait a minute, what about murder? What about those who've been convicted of murder? Nearly half of the group that was serving life in prison were convicted murderers. And so how do we proceed next? Well, what you need to understand is we already talked about the general group. It's kind of low to begin with. So what about the actual person that we're concerned about today, which is Mr. Amato? Well, what about him? That's when we take a look at the personality of the individual, their historical background, and to see if they have any of the empirically derived personality.
Okay, this has nothing to do with trial, law, true crime, nothing. Okay, for those of you familiar with Grogu and the Mandalorian, Grogu has a little front flying pram that follows the Mandalorian around. Grogu will get a mini droid. This is a droid that it can carry your stuff for you up to 20 pounds, which isn't very much, but anyways, and it will follow you. It uses the same technology as Grogu's pram. It costs $2,875. It's a droid. A real live droid that will follow you and carry your stuff. Real world, not CGI. Like a real droid that will follow you. It costs almost $3,000.
And historical risk factors which would predict higher rates of violence. So then we can now go into talking more about Mr. Amato. Under 8, what are the factors that would predict somebody's potential for being violent? Well, these individuals who are prone to violence have a history of prior violence. They have exhibited violence at an early age. They, as adults, have relationship instability, employment problems, substance use problems, a major mental illness, psychopathy, that's a fancy word for psychopath, early maladjustment, personality disorders such as antisocial personality, borderline personality, narcissistic personality, and a tendency to be impulsive or a propensity for impulsivity.
Did you find any of those factors after doing your evaluation of Grant Amato?
No. in fact, he has a very clean prior history as it relates to the type of people who are prone to be violent. Now, I should point out, I'm not here to dispute the finding of the jury today. I want to make sure that that's very clear. The jury has spoken. Mr. Amato has been found guilty of these crimes, and obviously they're violent crimes. What we're talking about is other factors that predate that can go into our analysis, because our interest is what will he be like outside of the context in which those murders occurred. How about in the future, what will he be like? And as you see, and for sake of brevity, they're up there for you to review. He has none of those.
Okay. So,
Hey, Carla.
are there other items of data or demonstrative aids that will help the jury to understand the conclusions that you've drawn in this case?
Sure. Number 9, we have 2 graphs to share about the relationship of age and violence, and how most of the violent behavior occur in individuals who are much younger than Mr. Amato. Here we go. And maybe even possibly blow that up just a tad, since
Yes, sir.
it's, there we go.
And you have, oh gosh, you have a pointer that you'll be able to utilize to help.
Correct.
Okay.
So the
Stop it.
vertical axis is standardized arrest rates per 100 individuals or arrestees. And along the bottom, let's see.
Is it working?
There we go. Along the bottom, we have age. Okay. Now, the importance of this graph is that what we're considering about this sentence is, what is he going to be like as he ages? Because Mr. Amato, should the jury decide on this sentence of life without the possibility of parole, will be considering what he will be like as he goes through his aging process while incarcerated. What you can see here in this spike right here, which is roughly about age 18, the vast majority of arrests occur with individuals who are right in their late teens, early 20s. And then you see you have a fairly precipitous declining function across time, so that as individuals age, and I'm highlighting the number 30 because that's where Mr. Amato is right now. He's 30 years old. He's already well past the peak and on the downhill slope. What that does is it provides a certain amount of reassurance that, all things considered, as people age, they, in a sense, have the wind at their back. They're less likely to engage just as a function of age. And clearly, as they get past about 40, it really starts to drop down towards 0. So the older inmates who are serving life, they're not acting out in prison. They're not. The acting out group, the ones who are giving all the trouble to the authorities, are right here.
I know. You're my go-to.
Okay. I've got another graph, Doctor. Would you like me to put
Yes,
that
and
on?
I think that will further illuminate what we're trying to describe here.
I turned off the keyboard. You can stand on it.
So this graph, and again derived from empirical research, is, as you can see across the top, this is the average number of prison rule violations per inmate per year by age. On the vertical axis, we have yearly violations. We have age cohort groups, 17 or less, 18 to 24, 25 to 34, etc. Again, same function is seen here. We see here the 18-year-olds, and I would bet you $1 that most of this is the early 20s, 18 to 22-ish. they're the highest. 25 to 34, which is Mr. Amato. 35 to
Val
44,
Kilmer's my
they
favorite
have
Batman.
0.6. And over 45, which we saw on the other graph, it pretty much is down towards 0. So again, in both of these graphs, you see that as people age, there's less and less likelihood of
I said I turned the keyboard off. You
difficulty.
can
So
stand
if
on it.
he were to be given life in prison,
I told her not to touch any buttons.
age
She won't
would
stand on the
be
keyboard
a
now.
factor.
I turned it off.
But I think that the other things which we showed earlier about his lack of any of the factors probably speaks most loudly to me about
It's moved now.
what it is
Got
that
more
maybe
room.
factor 8. I think as we look at him, although age is on his side, the primary finding is prior to the commission of these crimes,
Oh yeah,
he brings
he was the
nothing
best Batman ever.
that would indicate the possibility that he's likely to be violent.
All right. So we go to the 10th one, the 10th aspect of this. So when the contextual factors of low rates of violence for life sentence inmates and Mr. Amato's lack of the personality and historical factors correlated with violence are taken together, your conclusion is?
That he's a low risk for violence while serving a life sentence. And additionally, we have a list of other factors which are not listed in our factor 8, which particularly looks at prior violence, because I think one of the things about Mr. Amato, if you look at his educational background, his employment, I think he's not only someone who's apt to be free of disruptive or violent behavior, but quite frankly, I think he has a reasonably good likelihood of being a model inmate. And I think there are some other additional factors.
But before we leave this though, so what you're indicating is that Mr. Amato's age, which is currently 30 years of age, is a factor that the jurors should give due consideration in their deliberations.
Absolutely.
All right.
Meredith, I like the Riddler.
Now,
Frank Gorshin.
I've shown you those. I've shown you the documents that have been entered into evidence, the birth certificate, the lack of a prior criminal history, with the exception of arrest where no information was filed.
How about you sit in my lap?
School records.
I won't touch you. Just sit in my lap.
The professional
Sit in my lap.
license,
I won't
which
touch
is
you.
currently a critical care registered nurse license that's
Yes,
currently
that's you.
active. All of those things in conjunction with your evaluation of Mr. Amato, did you develop some additional factors that you believe the jury should consider?
Yes, because the number 8 on that list is research about violence. And there's a broader analysis that I think deserves some attention. These are probably secondary factors, but go to the issue of the type of adjustment that I would expect to see should he be given life in prison.
Okay. And in the context of additional factors to consider, have you prepared a list for the jurors to look at while you explain those particular factors?
Yes.
Would you like me to show it now?
Yes, I think that would be helpful.
Oh,
Now there's some of these are overlap from the earlier discussion. One of the things about individuals who act out in prison is not only do they have violent historical like prior arrest convictions and so forth, but they have criminal convictions for a whole host of other behaviors, dealing and using drugs, all sorts of things. He has no prior criminal convictions, so he doesn't have a criminal history. We already talked about the other two, so I will skip over those. Also, the period of incarceration where there were no DRs or disciplinary reports. The other thing about prison is it's highly structured. And the individuals who have a hard time coping and therefore are at higher risk for acting out have demonstrated almost universally a history of poor ability to adjust to structure. So when I do an interview with somebody and I ask them about their work history, I always ask them, have you ever been fired? Have you ever quit? Have you ever come late to work? Have you walked off? Have you stormed off, yelled at the boss, got in fights with the coworkers? Those things are tells, those are indicators. And so what you see here is his school records, which I reviewed. He has no suspensions. You know, a lot of these, when they're kids, they get put in out of school suspension. They'll tell me they were expelled, put in alternative school. Work, of course, we know he had that one incident, but other than that incident, which maybe the jury's aware of, where he was accused of mishandling some medications, his work history is very good.
Yeah, he did a lot of voice acting, and we lost a great voice actor last week. Tom Kane. He was 64. He had a stroke in 2020, and he died I think it was last week, from complications of the stroke. His name was Tom Kane. He was the voice in the monorail that says, "Please stand clear of the doors" at Disney World, and the narrator of the nightly fireworks show. And he was in the Clone Wars cartoon. He was the voice of Yoda. And some of the stormtroopers. All kinds of different voices in Star Wars. And if you watch Star Wars, any of the Star Wars celebrations, the Star Wars, it's like Comic-Con that they do. I think they do it it's either every 2 years or every 4 years, and they put it on YouTube. But the year that they did it in Orlando, he was a full presence at that one. And they did like stage plays with the voice actors from the Clone Wars, and he's there doing all kinds of different voices. And he died last week, but he was extremely talented voice actor. His name was Tom Kane. He was very, very good. So we've lost a very, very good. He was only 64. Very, very good voice actor. So voice actors they're just as talented as actors in front of the camera.
Good. We already talked about his adjustment in jail. He has no history of substance abuse or alcohol abuse. This is very important. Unfortunately, although it shouldn't occur, there are substances that people can get their hands on in prison. Shouldn't be, but it is the case that they can brew up Bach, as they call it, which is homemade alcohol. They can smuggle in somehow or other drugs, but that's not going to be a problem because he doesn't use or abuse drugs. He has no drug use history. And although he does drink socially, he's not really a drinker. I didn't diagnose him with a mental illness. He has some features of a dependent personality disorder, which we can talk about at some length, but no significant mental illness, no bipolar disorder, ADHD, schizophrenia, schizoaffective disorder. We know that brain injury or neurological impairment can be risk factors. He has no history of any ever being in a coma, neurosurgeries, none of these sorts of things which can reduce inhibition to act out. I don't think he has any features of an antisocial personality disorder. He's certainly not psychopathic. We talked about behavioral disruption in school. I think one of the interesting things about Mr. Amato is that he got a bachelor's degree in nursing. And I don't know how many people that you may know who are nurses, but they are caretakers. every nurse I've ever known has always been a caretaker type of person. They care about people. That's what you have to do 8 to 10 hours a day, is provide care. This suggests that he certainly could find something constructive, some pro-social type of activity, working in the library, tutoring, helping people get a GED, whatever. He could make use of his remaining years incarcerated, should he be given life in prison. He has a good capacity for social relations in the community. He had friends. He and his brother, Cody, had a circle of friends they hung out with. That's important because you really have to be able to kind of get along and maneuver around in prison to stay out of significant difficulties. And so the fact that he has that capacity, I think, is helpful. And of course, we've already talked about the other factor. And as I conclude, all of these factors would further argue against imposing the death penalty.
All right. Now, the codependency disorder that you refer to, is that a personality trait that would lend itself to violent behavior or being a management problem?
Well, first of all, he doesn't have a diagnosable dependent personality disorder of anything that because obviously I'm looking to see on the converse, is this somebody that I can say something positive about? And if it's not there, it's not there.
Oh my God, that 9
And so in that investigation, the only thing that I could see that would suggest any kind of personality disorder was dependent personality disorder, but he doesn't have it. He has features of it. That is the fact that he was living at home. He had not really gotten out on his own. I think he was overly enmeshed, in a sense, dependent on his family.
1982.
And the dependent personality is an easygoing, caring, non-combative, non-aggressive type. And again, I think that's overrepresented in teachers, nurses, and I say that in a positive way. But these are people that are almost never presenting with aggressive behavior.
Okay. So, yes, ma'am.
All right, so sorry to interrupt, but at this point, let's just take a 5-minute recess.
Essentially,
Doctor, you can step down if you need a stretch break, but you can't talk to anybody, including the attorneys, because you're still on the stand. All right, Mr. Leichel,
I'll take advantage of that break myself.
how much longer do you think you
I
have?
had one more question, Judge.
I
I'm sorry.
apologize. I just had a flag that one of the jurors needed a break.
His conclusion, and that was done.
Okay, well, we'll do that then when we get back. Mr. Stone, how long do you anticipate that your cross will be?
I don't know, maybe 15 minutes. 20
Okay.
minutes at the most.
So then we'll go through and then we'll release them afterwards for lunch and then we'll go
Sounds
through
great.
instructions. Okay. All right. You may proceed, Mr. Leichel.
Yes, Dr. Carpenter, just one more question, and you've already answered it once, but I would like you to please go ahead then and state for the jury your expert conclusion with regards to Mr. Amato, should he be sentenced to life in prison.
I don't imagine they're grown.
Sure. Basically, as I said earlier, I don't believe that he possesses any of the historical or behavioral characteristics that would suggest that he's likely to be violent or to present major management problems for the institution and staff.
Like hiring a hitman?
I also think that in addition to that, there's a good likelihood that he could be productive and well-behaved inmate should he be given life.
Thank you. No further questions, Your Honor.
State cross-examination.
Thank you. Good afternoon.
Good
It's a
afternoon,
couple of
sir.
minutes after 12, so I'll say good afternoon.
Yes, good afternoon, sir.
Got a few questions I want to ask you, and I'll try to be brief. We spoke last week. You were gracious enough to make yourself available. I think it was on Thursday that we spoke.
Correct.
And you we talked about what you did in this case. Of the times that you've testified in a criminal prosecution, in a criminal case, can you give the jury a sense of, in a percentage way, the percentage of times that you've testified for the defense versus testifying for the prosecution?
Sure. And I'm going to give that long answer, Mr. Stone, that I gave you, because it really depends to some extent. I want to give a little bit of detail. So I know it sounds like a simple question. Most of the times that I'm retained by a lawyer, it's for the defense. So I don't get a lot of calls from the state at the beginning of a case. However, I do like I said, probably 500 cases a year. Probably 400 of those are competencies. Is this person capable of proceeding with a case? When there is a disagreement between the state and the defense about my opinion, they have a competency hearing. And in those, when I've been retained actually by the judge, because that's who calls on me to go out to the jail, probably about 60-40, it's actually, it's about 50-50 state and defense. So in that instance, it's about half and half when I've been called by the neutral party, which is the judge. To be simply retained as I was here, it's probably 98% of the time it's a defense attorney. And quickly, when I used to do a good deal of child abuse, child neglect cases for the Department of Children and Families, I was their witness, which actually made me a state witness, and that was 99.9% of the time. So that's kind of how that breakdown comes in.
But because when the Department of Children and Family retains you, that's not really a criminal process.
No, it can morph into that if it's child abuse and so forth, but it's a civil matter.
Okay, but in the context of criminal prosecutions, and correct me if I'm misstating this, and I want to make sure I heard you correctly. In the context of criminal prosecutions, you're retained well over 90% of the time by defense.
Correct. If it just from the beginning, as the case is coming together, I'm probably 90-95%.
It was, so they
called by the
ruined it
defense.
at the end.
Now, also, when Mr. Leica was asking you questions, you made reference to Mr. Amato, and I'm referring to Grant Amato. You made reference to his arrest in Orange County.
Correct.
Are you aware that that arrest in Orange County was for his theft of propofol?
That was the allegation, correct.
Right, and do you know what the underlying allegation or basis of those facts are? What was he doing?
They didn't have orders for it.
Well, I didn't see the arrest record as I saw the police reports for this case. The propofol case, I was given some background by his attorney of what happened, and I was given that no file that we talked about earlier from the state attorney. When I asked Grant about that, because obviously I wanted to find out, this issue about his criminality, the way he explained it was that he was accused of stealing propofol, but what in reality he was doing was he was breaking protocol for the hospital because it's a controlled substance, as propofol. As he explained it to me, because he had to give several doses, the hospital wanted you to sign out every time you took a dose out because it's a controlled substance. What he was doing to cut a corner was he would take all that he needed and sign it out, and then he would have it in the patient's room. So when it was time for the additional dose, he didn't have to go all the way back and go through the signing out of the propofol. He claimed that he didn't steal anything, and as it turned out, I assume that's what the state concluded.
No.
Well,
No.
he took the propofol without authorization.
Well,
He didn't have authority to
He said
take
he
the
didn't have an
propofol.
order.
Is that a fair statement?
I don't really know enough about it, Mr. Stone, to debate the point. If that's the case, I'll take your word for it.
And
no, he lied to you, dude. He was stealing drugs.
he decided on his own, and you tell me if you believe this to be the case. He decided on his own to administer propofol to patients without a medical doctor's authorization. Is that a fair statement?
Again, I didn't see the charging documents. I don't know much more than I've already testified to about that case.
Are you aware that he admitted to that?
Again, if I'll take your word for it, I'm sure that's accurate.
Yeah, lied to you.
Now, you also made reference to a report of Dr. Cruz. Let me, do you have that report?
Yes, well, it's available. I can find it while we're talking. I think I may have already put it away, but here we go. I got it.
And that's something that you considered in doing your work in this case. Is that a fair statement?
That's correct.
I want to direct your attention to the portion of the report that says recommendations.
Correct. That's the title page, so to speak, right on the front. The lower box.
Well, yeah, exactly, the lower box. Can you read that recommendation to the jury, please?
This is front page, right on the bottom.
May I approach her? I want to make sure.
Is that where you wanted me to read from?
Yes, please.
Sure, be happy to.
Thank you.
The recommendation, client is not able to practice with reasonable skill and safety at this time, would recommend oversight supervision for a period of time to ensure client is using good judgment in caring for his patients due to the severity of his actions and random toxicology screens to rule out an alcohol use disorder.
And let me ask you this question, continuing with Dr. Cruz's report. And once again, you correct me if I misheard you, but when Mr. Leica was asking you questions, did you indicate that there was no signs of any type of substance abuse?
That's correct.
Okay. Well, can I ask you just to read the same page, the top box where it says synopsis of evaluation?
Sure. Client does not exhibit any signs or symptoms of a mental illness or substance abuse disorder. He denied any history of illicit drug abuse or alcoholism. However, based on his toxicology test, he may have an underlying substance use disorder.
And you, once again, during when Mr. Leica was asking you questions, you made reference to Mr. Amato, and once again, I'm referring to Grant Amato, Mr. Amato's licensure as a nurse.
Correct.
And and I think you said that you're assuming that he's still licensed.
He asked me if I believed he was still licensed, and when I looked at those exhibits in the folder initially, it looked as if the license was active. Now, it's possible since this arrest that his license may have been pulled, but I don't know that to be the case one way or another.
Right, and that's really what I'm getting
Right.
at, is the fact that he's been convicted of 3 counts of first-degree premeditated.
When a nurse has a substance abuse disorder, they don't pull their license. Now, I would think that if you're giving, in his case, he gave propofol to patients that didn't have an order for it. That is a lose your license offense. But that's up to the nursing board. That's not up to the hospital. The hospital doesn't yank your license. They can fire you, but you don't lose your license by the hospital. That's up to the nursing board. And they have, I know in Florida, I don't know about other states, because I've had to supervise nurses that do this. When there's a substance abuse allegation, they have a program for impaired nurses, and when you go into that program, you're not allowed to hold the keys or have the codes or however they lock up drugs. You're not allowed to do that. So I worked with a nurse that was in the program, and if she needed to give a narcotic, I had the keys to her narcotic cart, and I had to unlock it, and it's stupid because I unlocked it and I didn't give her patients the drugs. I unlocked it and gave her the drugs to give her patient. Does that make any sense? Absolutely none at all. But it's ridiculous. It's almost like, I mean, they don't get rewarded, but like, they're still around the meds that they stole. I don't understand. Of course, they're still going to find ways. Like I said, I unlock her cart and then I give her the medicine. She still got access to the medicine. I just have the key. It makes no sense. Absolutely no sense. What would make sense would be if I took that medicine and gave it to her patient. But no. It's so stupid.
Murder, you think it's a fair or safe assumption that the state of Florida would revoke his license?
Oh, yeah, I would say yeah, I wasn't sure that was the direction of the question, but.
Well, now they will, because he's a murderer. But they should have when he gave propofol to patients that didn't have a prescription for it or an order for it.
And you also mentioned during your direct examination when Mr. Lacka was asking you questions, and I'm going off of the chart or the factors, the 1 through 10 that you and Mr. Lacka were talking about, and the very first factor or observation is violent behaviors and interaction between between circumstance and personality.
Correct.
And those hearings are no joke. They made us go watch one when we were in nursing school. That is scary. It's not like a court of law where, like, you know, you have rights as a citizen. No, it's not like that at all. You have no rights. You're just under their rule, their jurisdiction, their everything. The nursing board has all the rights, and you just have to sit there and do whatever they decide they want to do to you.
Is it fair to say, and this may be pretty common sense, but is it fair to say that we don't know what circumstances Mr. Amato would be confronted with if he gets sentenced to life in prison? What circumstances he'd be confronted with in prison?
That's correct. It's a crapshoot in a sense. We have no way of knowing. We have some general inferences about prison that I know about, but any number of things, I suppose, could potentially occur.
Okay, that could result in violent behavior. I know your ultimate opinion, and I understand that.
Yeah.
But we don't know what circumstance may present itself in prison to Mr. Amato that would result in violent behavior. Is that a fair statement?
We
Like
don't
right
know
in his
what he
hand?
might encounter. That's certainly correct.
Okay, I said it 3 times. Now I'm done.
Now, also another a thing that I just want to ask you about is the chart, and this one I'll put up on the overhead. The indication there that the 2.6, and what's that, 2.6%? Is that what that is?
No, that's incidence of, and it's averaged across the group. So if you have 100 people
All right.
and you average it, so forth, it comes out to an average of 2.6.
And that's for people who receive life sentences.
Correct.
And would it be a fair assumption to conclude, or would it be fair to conclude that people who receive life sentences are put in a much more controlled environment in prison, such that any opportunity for violent behavior would be much limited? Is that a fair statement?
I don't think it's exactly a fair statement, Mr. Stone, and let me explain this. And I don't have this data, but this is anecdotal from my 30 plus years of working in this arena. If you do well, and he will very likely start out in a maximum security prison. I would venture that to be a strong likelihood.
Right.
However, if you do well as time goes along, you can be moved to medium security, and how far down that scale, there would probably be a floor. He wouldn't get to work release or something of this nature, obviously. But if he does well and has no DRs and so forth, and he has a job and he's helping people get a GED or whatever he's doing, I think he could eventually move. That data, I don't know which of those two situations that data came from, whether it was max or minimum security or what, or some composite. But I think the best way to understand it is its relative stance to the other categories.
Okay. And well, let me ask you, you see 1.61 in death row. Obviously, that's a significantly more controlled environment, death row, less opportunity to be violent. Is that a fair statement?
That is a fair statement. And I think that there's like a little piece of paper or something on it. It should, there's something written under there. But it's, yes, death row is what it indicates.
Okay. Now, you also spoke about age being a factor that's something for the jury to consider, but I want to try to refine that a little bit more. Is it fair to say that age is a factor the jury should consider in the context of your opinion regarding the likelihood for future violence?
Yes.
And now are you aware of the various mitigating factors that exist in the Florida statutes?
I know them. However, I didn't brush up on them because of the nature of my presentation today.
Okay. Are you aware that age is a statutorily listed mitigating factor?
Yes, I know that.
Okay. But in the context of what we're talking about today, your emphasis on age is only put forward in the context of your opinion regarding future dangerousness, and not that separate statutory mitigating factor of age. Is that a fair statement?
That was my intention, the former, which was to just talk about that as a factor in the equation for predicting future violence.
Okay. And just actually one more question, I think. One of the in that that 1 through 10, the Mr. Amato clinical forensic evaluation that you and Mr. Lyko spoke about. The
Correct.
10 points that you observed. Number 7 is then that we next look at the personality of the individual to see if they have empirically derived personality and historical risk factors predicting higher rates of violence. And then 8, you say these factors are, and you list a number of factors. And among those factors is employment problems.
Correct.
Are you aware that Mr. Amato was fired as a result of the incident in Orange County?
Correct. And I think when on direct, I think I tried to, because I was aware that, hey, to the jury, that might be confusing. Wait a minute, he got fired for the profanol. I wanted to expand on that, and I think I did, about coming late, leaving work, yelling at the boss. It's a pattern of repeated, it's not a one-off situation like this one.
Okay, I appreciate that. And you also mentioned relationship instability.
Correct.
I'm sure that in your work in this case, with all the materials that you reviewed, you're familiar with a person that is called, or a woman named Sylvie?
Yes.
Okay. I'm not going to get into the specifics about that. The jury's heard all about that. But let me ask you, would you consider that to be a stable relationship?
Not in the sense of that factor, no.
As a matter of fact, would it be fair to say that it's a very unstable relationship?
Well, it's probably somewhere in the middle. And we can get into it if you'd like, but as I told you Thursday in our deposition, one of the things in my practice over 30 years was encountering this internet love affair thing, which when I started, there was no internet. And having, again, all these 15,000 odd cases, I've heard just about everything, I think, in my life now. This internet love affair thing is something that I would always, in the back of my mind, think, you fell in love with somebody in England, you left your husband and flew to England to marry this person, this kind of thing. It was always a head scratcher, but so I want to say that this is a new breed of cat that we're looking at. It certainly had aspects of dysfunctionality about it that if he were my counseling client, I would have wanted to talk greater length about. But to say it in that binary kind of way that it was 100% dysfunctional, I would have to take a little bit of issue with that.
Okay. All right. I appreciate it. Thank you very much, Doctor.
Oh, you're a quack.
Redirect.
It's not 100% dysfunctional. What is wrong with you?
You have the evaluation of Dr. Perez up there with you currently, Doctor?
Cruz?
Dr. Cruz, I'm sorry. Yes,
Yeah.
sir. Dr. Carpenter, could you refer back to the toxicology drug testing results? I think it's like maybe 1 or 2 pages long.
Yeah, I have it.
Okay.
I may have put it away. I can get it out, but for sake of time, I can tell you they found metabolites of alcohol in the toxicology report.
Or ETG.
Right, and as I say, I can give the $5 word.
But all of the other substances that are listed there, be they opioids, be they, all of the, 2 pages.
Yeah, it's very, very extensive.
And the only thing that they found was a residual ETG for the consumption of alcohol.
Right. And what I should say is that these are metabolites of alcohol that only say that he had consumed an alcoholic beverage in some period of time. I couldn't give you the exact time span. So if you had a beer at dinner and went in the next day for your toxicology exam, that would show up.
Okay. Certainly nothing to indicate alcoholism.
No, and I think it's interesting that his diagnostic impression is rule out alcohol use disorder. And he also says random toxicology to rule out. So as strong as he was willing to go was to say rule out. In our profession, rule out means consider the possibility of. I can't rule it in. I can't rule it out. I'm going to call your attention to this. You keep an eye on it and do a toxicology screen down the road. So if you reinstate him, this guy may have a drinking problem, so you better monitor it. But it was only based on the metabolites of alcohol, which, as I say, if you had a beer when you got home from work and took the test the next day, would show up.
Are you familiar with the organization Physicians Recovery Network, or PRN?
Yes.
That is the body that's charged with supervising healthcare professionals to make sure that they do not have issues with substance abuse disorders or mental health disorders.
That's correct.
And I believe the recommendation in there was for Mr. Amato to be subject to a period of supervision by PRN. Is that correct?
That's correct.
All right. Finally, doctor, last thing. Now, in referring to statutory section 921.141, which contains the aggravators and mitigators, you indicated you're aware that age at the time of the offense is how it reads in the statute, correct?
Correct.
All right. It does not specify a specific age, does it? Like you're 18 or 19 or 55 or 65. It talks about age at the time of the offense. Is that correct? Okay. So when we discuss these graphs here, we are talking about these in the context of Grant Amato's age being 30 years of age. Is that correct?
Correct.
All right. I have no further questions. Yes, Your Honor.
All right.
Thank you,
very
Your
much,
Honor.
Doctor. You're excused and you're released from your seat.
My pleasure.
All right, members of the jury, we're going to take our lunch recess at this point. We're going to come back. Actually, can you all approach?
Yes, Your Honor.
We're going to come back. I'd like to start up at 10 till. All right, so you got about an hour and 20-minute lunch. Okay, and so if you could be here though, just a few minutes before, so maybe we could try and start up at 10 to 2. Okay, all right, so we'll see you then. Remember, don't discuss anything. The same rules apply during the penalty phase. Don't discuss anything with anybody or look at the internet or media or anything. All right, thank you. All right, now let's talk about the jury instructions. All right. Let's do the first one.
Mr. Shapiro is going to do the jury.
Well, I actually anticipated the state was going to make arguments about their modifications or special instructions.
Understood. All right. So the first one, we've got the prior violent felony aggravator aspect with that sentence. My understanding, okay, I've looked at James. So other than that, anything else to add, Mr. Stone?
No, just for that particular aggravator, just that, Your Honor. James versus State approved it. I think, and it's a statement of the law. That's what the law is. It's not covered in the standard instructions. It's something that the jury needs to understand. So it's not covered in the standard instructions. It is clearly an accurate statement of what the law is. And what I put in, the addition that I put into the standard instructions is literally a quote from the James case.
No, I noted. It's specifically in there. All right. And your indication is as to why it should be is because of the fact why?
Well, the reason is because it's not in the standard instructions. As a matter of fact, that case, which was a Seminole County case, and it involved Judge Dickey. Judge Dickey gave it. In this case, I'm reading from head note number 7. In this case, the trial court instructed the jury pursuant to the state's request, and then so on. And so it's obviously something that's approved by the Supreme Court. They found no error. You know, as I said a moment ago, or argued a moment ago, it's not contained in the standard instructions, and it's not something intuitive that the jury would understand. So I think it's important the jury understand that.
All right. Mr. Shapiro?
Judge, our objections actually don't apply with this argument.
I'm sorry?
Our objections to the special and standard or special instructions and the modifications that the state wants don't have anything to do with their first argument. So I really don't have an objection based on the case that I've read.
Okay. All right, you could have said that in the beginning.
Right. I'm sorry, I didn't want to interrupt you.
All right, okay.
But the second two is where we have objections.
All right, so the first one, the court, based upon the case law, it's completely on point, so the court would allow it. All right, okay. Well, then you're objecting to the second two.
Judge, yes, the state appears to want to include a jury instruction regarding lingering or residual doubt. Now, the state's case that they provided.
Understood. Let me ask the state. Mr. Stone, why should I give the aspect of the lingering doubt instruction?
Because, you know, once again, that's what the law is. It's not contained in the standard instructions. And we don't know what the jury is thinking. The jury may well, during the guilt phase, have said, well, you know, we heard the argument. We know what reasonable doubt is. The court informed us what reasonable doubt is not. It's not a possible doubt or a forced or a speculative or imaginary doubt. And they may, we don't know if they went back and deliberated. Well, you know something? We kind of have those doubts where it's possible we're forcing ourselves, but we're going to follow the instructions. That's not a reasonable doubt. So we're going to find the defendant guilty. But we don't know if they had those kind of doubts. So it doesn't hurt to inform them that if they're thinking, well, it's possible that he didn't commit this crime, or we can speculate, and some of them may be thinking that.
Okay, well,
it's important for them to understand that that's
let me ask you this, all right? Because they've already had the guilt phase and they've already found him guilty.
Correct.
All right. And if neither side, if the defense is not even arguing lingering doubt in regards to the circumstance that there may be residual or lingering doubt about the defendant's guilt, we've already passed that phase. Why is it that
when I was a kid, I thought the rumble strip sounded like the Jaws theme, you know? And so my parents and I would play a game when we hit them. Get down, Debbie, get down, the shark's gonna get you. And so I would get on the floor of the back seat, because back then you didn't have to have seat belts or car seats or anything like that. So, get down, the shark's gonna get you, get down. And I get down in the back seat until we were past the rumble strips. And then, okay, you can get up now, shark's gonna... I was a weird kid. I'm a weird adult, but I was even weirder as a kid.
the court should bring that up? How is that in something that should be added towards a special instruction? I mean, in looking at it, I realize what you're stating, but there isn't anything, I was trying to find if there's anything specifically instructing the jury on this point.
No, it's not in the standard instructions, and that's the reason why it's important. It's just simply a statement of the law. I don't know how it can hurt to inform the jury that that is not a mitigating circumstance. The court's going to inform them that I can't think of it verbatim, but I can look at it and tell you.
However, a mitigating circumstance does not include any residual or lingering doubt you may have about the defendant's guilt.
No, I'm not talking about that. I'm talking about the court's going to instruct the jury that they can consider any aspect of the case or the defendant's character or the defendant's background. Well, any aspect of the case.
Okay,
that may well, we don't know, but it may well include some type of possible or lingering doubt.
Okay, we're going to skip the charging conference.
All right, Mr. Shapiro too?
They will be working on the verdict form. And I don't know when they're coming back, so that will be handling the rest of the proceedings. So we can.
Okay, well, originally I was told Mr. Shapiro was arguing the jury instructions, so that was just the only issue.
I don't know if council's aware, but the verdict form was included in what I sent over, Your Honor.
I know, I don't know if council's aware of that, but I know it was requested of my judicial assistant, and she had indicated that it was within the state forwarded the verdict form and the jury instructions on Thursday.
Right, I was not included in those discussions. I don't know what they do.
Okay, all right.
But we did send case law to Your Honor.
I did get it. Thank you. Okay. First, here, let me address, yes, Mr. Leichel. One thing too, I wanted to make sure I had a request regarding the verdict form, and I know previously the verdict form and the jury instructions were all provided the other day.
They were provided, but the verdict form is only at 6 states, so I have my staff trying to put together a verdict form with mitigators too, because they're not included.
All right, okay.
Well, Your Honor, can I point out something?
Yeah.
That verdict form is in the standard instructions.
I understand. And
it doesn't provide for the specification of mitigation that's been presented.
Well, they're going to do a proposed verdict form, and then I'm sure the court can then consider, and at least they could have their argument or have their record depending on what goes on. Or the court can consider it and grant it, depending on the circumstances. All right. Now, first of all, as to, where is that? All right, now, as to the jury instructions, which actually I still have sitting on my desk, and I asked my assistant to bring, but she must not have gotten my email. 1 second. Okay, now first, as to the aspect of the jury instructions, what the court is going to do, and specifically based upon the case law and the court reviewed, the circumstances as to the first sentence, the court is going to have it as conviction of theft is not an aggravating factor to be considered in determining the penalty to be imposed on the defendant, but evidence of that crime may be considered by a jury in determining whether the defendant has a significant history of prior criminal activity. Based upon the aspect that there is evidence of theft and pursuant to Walton, which the court had reviewed in the other case law, indicating that evidence of prior criminal activity can be entered into evidence to rebut that no significant history of prior criminal activity exists, and that the state is allowed to enter that evidence as a rebuttal rather than simply just convictions. The court would otherwise believe that it could be confusing to the jury for that evidence to be presented if the jury instruction says conviction in determining the aspect of significant history of prior criminal activity. So that portion of the jury instruction, the court is going to allow to be different as to the standard and allow it essentially as a special instruction, so to speak, based upon the circumstance that I believe it more accurately and adequately is a statement of the law and otherwise would take away any confusion from the jury. So that's number one. Number two, the court understands the memorandum as to the mercy instruction. The court is otherwise going to deny that request.
Yes, ma'am.
And that's indicated as well, which the court reviewed as well over the lunch hour. Then the last aspect as to age. Based upon, and there are actually several cases as to the factor. There's not only Simmons versus State, Washington versus State, Mills versus State, there's also Lara versus State, which is an additional one, 464 Southern 2nd, 1173, which is a 1985 Florida Supreme Court case as well. They've consistently held ages such as low as 23, 26.
Did the court get the benefit of the Tunador case?
Yes, but the Tunador case, when I was looking at that, trying to determine as to the application as to that mitigating factor, where it specifically, this indicates the middle age being considered.
This gentleman in that case is 44, Judge, and what it basically is saying that age can be a mitigating factor when it's coupled with a lack of a prior criminal history. That's what Tunador stands for.
Understood. And I guess I'm trying to figure out then is that how you are attempting to apply it? Because 44 versus when I'm looking at the other case law in regards to the 26, 23 or otherwise, a younger age is essentially.
Those cases are over 30 years old, Judge. Mine's from 2017, and we're dealing with a new law now, not the one that these cases were utilized for.
Well, when you say new law in reference to the aspect of the death penalty, that it has to be unanimous, but the mitigating factors and statutory mitigating circumstances, that law has not been changed.
Well, a great portion of Dr. Carpenter's testimony was related to the issue of age, that being Grant Amato's being at age 30, and the mitigation is that he should be given a life sentence based on his age, based on the empirical data that was testified to by Dr. Carpenter, and the fact that Grant Amato has no prior significant criminal history. He has a prior arrest, but no convictions. So under Tunador, which is a 44-year-old gentleman, the language essentially states that it is a mitigating factor, given the fact that he has a lack of a prior criminal history, meaning that he has specifically lived his life without violating the law, and he's 44 years of age. In the cases that Mr. Stone, his 30-year-old plus cases, all of those defendants have significant criminal histories.
So you're indicating you're going to argue the fact that he was 29 years old and that he hadn't had any prior criminal history coupled with that age before he was 29 years old?
Under Tunador, yes.
Mr. Stone?
Well, Your Honor, first of all, I don't know if there's any expiration or time date on Supreme Court case law, whether they're 30 years old or 1 year old, there's still, valid precedent. I think in that
Tunador?
In the Tunador,
which for the record is 221 Southern 3rd, 587, 2017.
His more advanced age compared to the defendant, coupled with the no prior significant criminal history, gains significance because after 44 years, he didn't commit any crimes. With respect to the defendant in this case, he's 29 years old when he committed the crime, and that's a lot closer to the young age of, turning an adult, 18, than it is with regard to the defendant in Tunador.
Let me ask you a question, because the one thing, the trial court, did you read Tunador?
I just got it a couple of minutes ago, but I read the particular part that dealt with the age mitigator.
All right, so the fact in that aspect, the court rejected it as a mitigating circumstance, and they found that they erred because of the fact he was 44 and no prior criminal history. And it was different insofar as it didn't pertain to the immaturity of the defendant. If they're restricted from not arguing it as an immaturity issue, but arguing it just as a time issue that however many years, 25, 29 years, not having a prior criminal history, and you're indicating that based upon Tunador, that would be inappropriate.
Well, I think the fact that he went from 18 to 44, which is 26 years without committing a crime versus 18 to 29, which is 11, has some significance. I think the Tunador case derives its significance based upon the length of time that went by without committing a crime.
At this point, what the court's going to do, it's going to go to the weight, not the admissibility. So at this point, I am going to allow that mitigating circumstance. If that's the way they're going to argue it rather than the immaturity aspect, then the court's going to allow for it. Okay. And otherwise, you guys can adopt as far as go from the jury instructions. We will have to, I'm going to need something proposed based upon the mitigating circumstances. With all due respect, I asked you guys to review these last week. That's why I had Mr. Stone complete them as of Thursday, and the court reviewed them in the verdict form, and it would have been easier to deal with that over the lunch hour had there been any issues in regards to.
It'll be done in just a few minutes, Judge.
Okay. All right. Otherwise, as to the other aspects of the jury instructions, were there any, other than the proposed mercy instruction, were there any objections to the proposed penalty phase jury instructions that were provided by Mr. Stone?
No, Your Honor.
Okay. At this point, so we're just waiting then on the verdict form. So the final instructions as to the entire penalty phase, it's just the verdict forms that are as to count one, Margaret Amato, count one, Margaret, count two, Chad, and count three, Cody Amato, are the ones that we're going to have to argue on a break then, it seems. Is that correct?
Yes, ma'am.
All right, I'd want them both emailed to Vanessa as well as to the state, so somebody can look them up and make sure and go over the verdict forms prior to, and then we can see as far as the argument and go from there.
Can we have an email to Ms. Atkins? Because she
Understood.
has her computer very wrong.
That's fine. All right. In the meantime, are we ready with the next witnesses?
Yes, Your Honor.
Who's the next witness?
Thomas Pachasik.
Okay, why don't we get the jury while Mr. Pachasik's being gotten. Deputy Bradley, can you go get Mr. Pachasik? The conviction on the third issue being changed on just that first sentence, and then otherwise deleting the second portion. The second aspect of the jury instruction, there are 3 highlighted points are here.
I made the two,
I'll email them to you.
I made the corrections, Your Honor, but we have to do a little more, I think.
Yes. All right, you may be seated. You may call your next witness.
Yes, Your Honor. Defense calls Thomas Pachasik.
Mr. Pachasik, come forward, please. Raise your right hand, be ready to be sworn.
You saw me swear or affirm the testimony you're about to give will be the complete truth, so help you God.
Yes.
Thank you.
Come forward as the deputy instructs you.
Okay.
You may proceed.
Good afternoon. Could you please state your name for the record?
Thomas Pekracek.
Pekracek?
Pekracek.
I am so sorry.
That's okay.
Say it one more time.
Pekracek.
Pekracek. Okay. Mr. Pekracek, what is your occupation?
I'm a nurse anesthetist for Team Health at Orlando Regional Medical Center.
Okay. And how long have you been working there in that capacity?
4 years.
All right. During that time period, did you get to know a gentleman by the name of Cody Amato?
Yes.
And how did you know Cody Amato?
Cody was a student initially when I first got there, and then he completed his training and started working there as a nurse anesthetist along with us.
Can you do me a favor, please, and spell your name for the court reporter?
Sure. P as in Peter, Echacek.
Thank you.
Okay. And during the time period that you worked with Cody Amato, did the two of you become good friends?
I would say yes.
Okay. Did that include spending time together, talking about each other's families, life, things like that?
Yeah.
And what were your impressions about how Cody felt about his brother Grant Amato?
I would say Cody would do anything for Grant. I mean, from one of the discussions was about driving. Cody had his ideal dream car was having a 3M Beamer, but he held off getting it because I guess Cody and Grant had a deal that they would both buy him at the same time.
Okay.
So
they were that close.
Yeah.
All right. Now, did Cody talk to you about the trip that they took to Japan?
Yes.
And when he talked about the trip to Japan, did he actually mention that he and Grant were planning a second trip at some point in time in the future?
Yeah.
And from what Cody told you about that trip, did it appear that he and Grant had a good time while they were on the trip together?
Sounded like they had a great time.
All right. Now, after Mr. Amato was arrested for these offenses and was in the Seminole County Jail, did you actually go to the jail knowing what he was arrested for and place money in Mr. Amato's commissary account?
I didn't go to the jail. I just did it over online.
JPay?
Yeah, I think.
Okay. How much money did you put into his account for him?
I think it was $20.
And is there something related to your relationship with Cody that made you do that?
I would say Cody was extremely caring, and just myself, I like to look for the best in people. I've had friends who have gotten themselves in trouble and wound up in the system, and that knowing what they went through initially, not having any funds was one of the reasons why I figured, like to make life a little easier for him. Because basically Grant went from having the most phenomenal support system to nothing.
And you felt like that's something Cody would have wanted you to do? Yeah. I don't have any other questions, Your Honor.
Good afternoon, Mr. Pekacek. How are you?
Doing wonderful.
You don't know Grant Amato. Is that a fair statement?
That's fair.
Never met him before?
He was already out of the program before I started.
And you put the $20 in his account before he was convicted of these murders, correct?
That's correct.
Knowing, if you knew then what you know now, namely that he was found guilty and convicted of murdering Cody as well as his mother and father, would you have placed that $20 in his account?
No.
And why not?
For me, it's hard to even fathom.
I'm sorry?
I'm just sorry.
No, go ahead. Explain, please.
For me, it's just hard to fathom the fact of the circumstances on how all three of them were killed. I mean, especially mom being shot in the back of the head with no warning. I mean, his dad crawling away for his life, and Cody just being set up. I mean, just couldn't do it.
So before trial, he's presumed innocent, and you operated under that presumption. But now, after having been found guilty, there was no way that you would donate that or contribute that money to his account.
Your Honor.
No.
Counsel's testifying.
I was about to ask you. Is that a fair statement?
That is a fair statement.
Okay. Thank you very much, Mr.
No redirect, Your Honor. Yes, ma'am.
You may call your next witness.
Fifth call, Jessica Bean.
Miss Bean.
You solemnly swear or affirm that testimony you're about to give will be the complete truth, so help you God.
Yes. Ms. Bean, come forward, raise your right hand. I'm sorry, have a seat. Yeah. Okay. All right, thank you. You may proceed.
Thank you, Your Honor. Good afternoon, Ms. Bean. Could you please state your full name for the record?
Jessica Edwards Bean.
And Ms. Bean, what is your profession?
I'm a nurse practitioner.
Okay. And you work here in the Central Florida area?
In Claremont.
Okay. All right. And how long have you been working as a nurse practitioner?
About 3 or 4 years.
Now, do you know Grant Amato?
I do.
Okay. And do you see Mr. Amato in the courtroom?
I do.
Can you describe something that he's wearing?
Blue tie.
All right. Let the record reflect Ms. Bean's identified Mr. Amato. Now, when did you first meet Mr. Amato?
We went to nursing school together, the last class of nursing school, and then we ended up on the same unit our last semester of school.
Okay. And when you say the same unit, what unit are you talking about?
ORMC, we were on ICC, which is a step-down unit, and we had the same preceptor.
The same preceptor. What is a preceptor?
It's basically a nursing supervisor, so oversaw students and placed them with people that they could observe patients with.
Now, when you describe an ICC step-down unit, what type of intensive care unit is that?
So it's critical care, patients that are too sick for a general unit, but not sick enough for ICU. So critical patients, ventilators, a lot of medications, that kind of thing.
Okay. So it's a little bit more intensive care than just a general hospital stay.
Yeah. Yes, I would say so.
Now, when you were in class with Mr. Amato at the University of Central Florida, I'm assuming that's where y'all took the class together.
Yes, sir.
Did you develop an opinion about what type of a student Mr. Amato was?
He was a good student. Our program was pretty tough, so you had to have pretty good grades.
Okay. All right. And when you were working at this ICU step-down unit with Mr. Amato, did y'all work the same shift?
We did. We were on night shift together.
Okay. And approximately how long did this particular, is it like a clinical?
Yeah, it was a full semester.
So how long is a semester? Sort of. How much?
Gosh, I don't remember.
More than 3 months?
Yes, about that.
And how many days a week would you work with Mr. Amato?
A couple days a week.
Couple of days?
Mhm.
All right. So 2 days a week over a 3 month time period.
Right.
So y'all had plenty of opportunities to work together during that time.
Yeah, we were also hired together as well, so we stayed on the unit.
Oh, you were both hired too?
Mhm.
Okay. And how long did you remain at, was this at Orlando Regional Medical Center?
Yes, sir.
How long did you remain in that employment before you moved on to your current position?
Approximately 2 years.
So you had the opportunity to continue to work with Grant Amato during that time period?
Yes.
During the time period that you were working with Grant, did you also meet his brother Cody?
I did.
Okay.
1 or 2 occasions.
On 1 or 2 occasions?
Mhm.
Did you get to see the two of them interact together?
Yeah, they were good friends.
Okay. Now, whenever you needed help with something, when you and Grant were working together, whether it was when you were in the clinical program or during the 2 years that you worked together there, was Mr. Amato a helpful person to you in your capacity?
He was.
Now, I know there's the term registered nurse.
Mhm.
Is there such a thing as a critical care registered nurse? Is that a title?
There is.
All right. Were you and Mr. Amato considered critical care registered nurse?
No, that was actually an extra certification. A couple of people on our unit had that, but then other nurses in ICU would have that certification.
What's involved in getting that certification to be a critical care registered nurse?
Studying and a examination.
Okay. Now, during the time period that you worked together, and I know it has nothing to do with what we're here about, but during the time period that you worked with Mr. Amato, was he a pleasant, nice person to work with?
He was.
All right. I have no other questions.
Good afternoon, Ms. Bean. How are you?
Fine, thank you.
You said that you went to nursing school with Grant Amato?
Yes, sir. I was in an accelerated program for people that previously had a bachelor's, and he was, I think, in a 4-year program. But he ended up in my last class with me. I'm not sure the circumstance, but so he was younger than I was.
Were you aware of any issues that Mr. Amato, and I'm referring to Grant Amato, had while he was in school?
No, I wasn't.
And you also told us that you worked with Mr. Amato.
Yes, sir, I did.
Were you aware of any issues that Mr. and once again I'm referring to Grant, that Mr. Amato had while working for ORMC?
Not while I was there. There was no issues that I remember being brought up.
Okay, but let me ask you, were you aware of any issues regarding Grant Amato at ORMC when you were not there, when you did not work with him?
No, sir.
You didn't hear anything, any concerns?
No, I haven't kept up with any of the case or literature.
Okay.
I'm sorry.
All right, thank you very much, Agnes.
Okay.
Any redirect?
No redirect, no, Your Honor.
Okay, thank you, ma'am. You can step down.
Thank you.
Excuse Your Honor.
Thank you, ma'am. You can be excused. Your next witness?
Defense will call Terry Robertson.
You solemnly swear or affirm that testimony you're about to give will be the complete truth, so help you God.
Yes, I do.
Thank you.
Please have a seat in the witness stand.
Good afternoon. Could you please state your name for the record?
Terry Robertson.
Okay. And Ms. Robertson, how are you employed?
I am a registered nurse and a nurse manager.
And what company do you work for?
Express Scripts.
Is that a subsidiary of Accredo Pharmacy?
Accredo is an Express Scripts company. Yes.
Okay. What, the other way around?
Yes.
Okay. All right. Now, you were working in that capacity, were you not, back in January 25th, 2019?
Yes, I was.
All right. Prior to that date, did you become aware of an individual who was applying for a position with Express Scripts by the name of Grant Amato?
Yes, I was familiar with his name. The nurse supervisor in Orlando, Erica Johansson, reports to me, and she had done a telephonic interview.
All right. And did you participate in the interview along with Ms. Johansson on January the 25th, 2019?
I did.
Prior to that date, did you get any of Mr. Amato's information, such as his resume or anything like that, before the interview, or was it the first time that you saw it the day that you went in for the interview?
No, I did receive a copy of his resume prior to the interview.
May I approach the witness, Your Honor? I'm showing you what's been previously marked for identification as Defendant's Exhibit G. This is a document obtained from Express Scripts. Do you recognize that document?
Yes, this was the resume we received.
Okay. Now, referring to the document itself, what did it reflect with regards to Mr. Amato's education?
He was a bachelor's degree prepared registered nurse, and he had partially completed his nurse anesthetist program.
That would be at Barry University?
Yes.
What was his GPA at the University of Central Florida?
3.4.
And the GPA at Barry University?
3.5.
Does the resume contain any notations of honors during his educational pursuits?
Yes, he was on the dean's list and the president's honor roll.
All right. Now, up at the top by Mr. Amato's name, there's a designation CCRN. Could you tell the ladies and gentlemen of the jury what that stands for?
That is a national certification for a critical care registered nurse.
All right. And what was the position that Mr. Amato was interviewing for at that time?
An infusion nurse.
Okay. Could you tell the jury what an infusion nurse does?
Yes. We provide nursing services in patients' home for specialty drugs. They're chronic lifelong therapies, or educate them to perform the infusions themselves.
And the infusion means you're actually putting needles in people. I'm not sure what the delivery system is.
Yes, the infused therapies are through an IV catheter. We also teach inhaled therapies and provide nursing for some specialized oral therapies as well.
Okay. And again, I'm trying to ask you to take this in the context of, prior to January the 25th or 26th, 2019, when Mr. Amato was arrested for the crimes of which he stands convicted today. But going back before that, his application process was proceeding along the lines of Express Scripts being very interested in him at the time, weren't they?
Yes.
All right. And this resume, if you could go to the second page, certifications and activities, and indicate what were some of the certifications that he brought with him when he came in for the interview.
He had a basic CPR card, an advanced cardiac life support card, which is an advanced CPR class where you can run codes and give direction to other people participating in them. He was, again, the CCRN, or the critical care registered nurse. He also had a PALS certification, which is pediatric cardiovascular CPR advanced life support. He was heart trained through ORMC. I believe that's a specialized class or certification program maybe the hospital provides, but I'm not familiar with that.
Yes, ma'am.
And
always ready for the recording.
Yes.
And as of the date that you were meeting with Mr. Amato, all of those certifications were current?
To my knowledge, yes.
Okay. Now, one of the other documents that we received from Express Scripts is a document entitled Interviewer's Guide for Express Scripts to be utilized in these interviews. Is that correct?
That's correct.
Do you have a copy of one that I provided to you earlier?
Yes, I do.
May I approach the witness, Your Honor?
From her company, we have our own copy.
Are you entering the resume and evidence?
Ma'am?
So are you entering that resume?
I'm going to be, yes, you're right. I would go ahead and move that resume that's been previously referred to as evidence.
Any objections?
No.
And that was pre-marked exhibit, is it G? Was been pre-marked for identification as exhibit G will be moved into evidence as defendant exhibit 7 in evidence, 6 in evidence.
May I approach the witness?
Yes.
Okay. You've got a copy of
Yes,
this,
I do.
correct?
Yes.
All right, I'm showing you what's been marked for identification purposes as defense exhibit F. I'm gonna trade with you.
Okay.
All right. This is the document that we received from Express Scripts. Now, is this the standard form that Express Scripts use when it's conducting an interview such as the one that Mr. Amato gave on January the 25th?
Yes.
All right. And this particular form that is in front of you, it does have on the front page candidate Grant Amato.
Yes, that's correct.
Interviewers Erica J. and Terry R being you.
Yes.
All right. Now, turning to the third page of the interview, this deals with accountability, taking responsibility for own actions and work, accepting the consequences of own behavior, admitting mistakes when appropriate. How do you generate the question from this particular page? How would you ask the question? Is that what's written in the box?
In the question 1, yes.
And what is the question
Sometimes.
in that?
Sometimes our decisions lead to difficult consequences. Tell me about a time when you took responsibility for a decision you made at work that didn't turn out the way you wanted it to.
Okay. And I'm not aware if you can read Mr. Amato's handwriting or not, but is that his handwriting or is that one of the interviewers?
No, that's Erica Johansson's handwriting.
Can you read Ms. Johansson's handwriting as to the response?
CVICU, surgeons, getting patients up the next day after surgery, doing what was best for patients, did not get patient up to 300 cc's of fluid.
Okay. And on that particular page, you have a rating system at the bottom of the page?
Yes.
And on that particular page, you rated Mr. Amato as a 5?
That's correct.
Okay. What is a 5?
Above average.
All right. And below that, there are some definitions of what is above average. Could you just briefly read those 3 things underneath above average?
Sure. Informed others about a mistake and openly accepted responsibility for it, regardless of the consequences. Accepted the consequences of one's own behavior without complaining or making excuses. Took sole responsibility for a bad outcome when appropriate, even if he or she may not have been fully responsible for it.
Okay. The next page deals with customer requirement skills. And again, what would be the customer's needs in the context of an infusion nurse? What would be some of the things that you would be looking at?
Well, we constantly assess patients as we're giving medications for adverse reactions. And we also advocate for patients and their families. But, you want to monitor and assess a patient very frequently to catch a bad situation before it can become very bad.
And in regards to this particular customer requirement skills, how did you and Ms. Johansson rate Mr. Amato?
We rated him above average.
As a 5?
As a 5.
Okay. As to the next page, detail orientation, what does that mean?
Would you like me to read the question that we presented him with?
Sure. Yes, ma'am.
Okay, striking an effective balance between attending to details and remaining focused on the big picture can be extremely tricky, particularly when you're under time pressure. Describe the work you completed that best demonstrates your ability to stay on top of details but not get overwhelmed by them.
Okay. And what did you and Miss Johansson score Mr. Amato as to that?
A 4.
And that is also above average?
Yes.
As to the next page, dealing with flexibility, could you go ahead and read the question as pertains to that?
Sometimes priorities at work shift very quickly. Describe a time when you handled a changing priority effectively.
Okay. And in response to Mr. Amato's response to you and Ms. Johansson, how did y'all score him on that one?
A 5 or above average.
Okay. All right, last page.
Those are hard questions.
Personalized service skills. And what is the question in that particular one?
Describe a time when you solved a difficult customer problem.
And in that particular case, Mr. Amato was not given an above average score?
No, he was
What
scored.
what score was he given?
He was given a 3 or average.
Okay. All right. Now, does this document that you're looking at, does that appear to fully and accurately portray the interview guide that you and Ms. Johansson utilized on January 25th, 2019?
Yes.
Judge, I'd move that into evidence.
No objection.
All right, what's been pre-marked for ID as Defense Exhibit F will be moved into evidence as Defense Exhibit 7 in evidence.
I don't have any other questions. Thank you, Ms. Robertson.
Cross?
Good afternoon, Ms. Robertson. How are you?
Good, how are you?
Doing well, thank you. You mentioned that you were talking about Grant Amato's resume, and you mentioned that he partially completed his nurse anesthetist program.
Yes.
Okay. Do you know why he did not complete it?
If from what I recall, in the interview, it was for personal reasons and it was too stressful for him, to the best of my recollection.
And that was his explanation.
Yes.
So you don't know that to be correct. Is that just
No.
from what he told you?
Correct.
And the resume that you were given was obviously given to you by Grant Amato himself, correct?
I believe it was our talent acquisition team that forwarded us the resume prior to moving forward with the candidate.
Okay, and then they obviously received it from him.
Yes.
Do you know if any effort is made to verify what's contained on the resume itself? Or
No.
is it basically an honor system?
From my understanding, there's no investigative background unless we decide to make an offer to an employee.
Okay. And an offer was never made in this case, is that a fair statement?
No.
Now, the interview took place on January 25th of 2019, correct?
Correct.
Were you aware of the issues that Mr., and once again, I want to say Mr. Amato, I'm referring to Grant Amato. Were you aware of the issues that Mr. Amato had at ORMC in June of 2018?
I was not.
Are you aware of it now?
Yes, I am.
What is your information regarding that issue that he had in June of 2018?
From what I've read, it was a problem with missing drugs and that were possibly taken to give to patients that were under sedated.
Okay. And given to patients by Mr. Amato without a doctor's authorization?
I would assume that was the only reason you would need to take those drugs, is if you were going to give them without an order.
And are you now aware that he was fired from that position at ORMC?
I am aware of that now.
And let me ask you this. Was that disclosed to you by Grant Amato during his interview?
No, it was not.
And if it was disclosed to you by Grant Amato during the interview, at that time, in January of 2019, would you have offered the position to him? You could give a fair answer, please.
Probably not.
Okay. And in the document,
And if he, as a, he was a certified critical care nurse. So if he had seen that the patients needed more sedation or more pain medicine or more whatever, all he had to do was call the doctor and say, my patient is in distress. They need to be sedated more. They need more pain medicine or whatever. All he had to do was pick up the phone and call the doctor and get a verbal order over the phone. Because you can do that. You can write an order if a doctor gives you a verbal order over the phone. All you have to do is write it and then write verbal order in the doctor's name. And that's all you have to do. So he didn't have to steal it and then administer it without an order. It's very easy to get an order over the phone, especially if you're a critical care nurse. So there was no reason for him to have done what he did. Absolutely none whatsoever. Unless he was stealing it to take home for himself. It makes no sense for him to have done that at all.
the interview guide that Mr. Leica was asking you questions about, the first part where it says accountability, taking responsibility for actions and work, accepting the consequences of own behavior, admitting mistakes when appropriate. The section right below it, the box that says situation, you mentioned that was filled out by Ms. Johansson?
Yes.
Okay, but I presume that's what she writes down, what she was told by Mr. Amato.
Well, yes.
Okay. And you have that document in front of you?
No.
You
it was
don't?
Submitted for evidence.
Okay. May I approach you? Was this submitted in evidence?
The one that's admitted in red right there.
Okay.
It's exhibit number 7.
Okay.
So we know he's a lying liar that lies.
The section, the page that's accountability, and the box where it says situation. Well, first let me ask you, this particular section, the accountability section, it's questions dealing with, accepting responsibility for mistakes. If you make a mistake, to be held accountable. Is that a fair statement?
Yes.
In that box with the situation that was filled out by Ms. Johansson, can you tell me, it reads CVICU, what does that mean?
Cardiovascular intensive care unit.
And surgeons next to it?
Yes.
And then it says below, and tell me if I'm misreading this, getting patients up to day after surgery?
Yes, getting patients up the day after surgery.
Okay. Doing what is, and then after that says doing what is best for patients?
Yes.
Would you consider giving a patient propofol without the authorization of a doctor doing what is best for the patient?
No.
No.
Not at all. Not in the slightest.
And the next page where it says customer requirements and skills, what is that? Can I ask you, what is that calling for? What's the subject matter of that particular page? Customer requirement and skills. What's customers? Patient?
Yes, or family.
Okay. And then in the box that that was filled out, it says the same thing, bleeding. Do you know what that means?
The
With
cardiovascular.
the word bleeding?
It was a scenario, from what I recall, in the CVICU, and the family had voiced concerns, I believe, in regards to chest tube output, which is bloody drainage.
Family concerns addressed. That's what it says. And let me ask you this question, kind of the same question I just asked you before. Would you consider giving a patient propofol without the authorization of a medical doctor, something that is identifying and understanding a customer's needs and expectations?
No.
The next one where it says detail orientation. What is that designed for, detail orientation?
Would you like me to read the question that we
Yeah,
asked?
could you please? Yeah.
Sure. Striking effective balance between attending to details and remaining focused on the big picture can be extremely tricky, particularly when you're under time pressure. Describe the work you completed that best demonstrates your ability to stay on top of details but not get overwhelmed by them.
Those questions are
Basically,
hard.
being meticulous and detailed about what you do under particular circumstances.
Yes.
Let me ask you once again the same kind of question that I asked in the two previous questions. Would you consider giving a patient propofol without the authorization of a medical doctor and no notation of it, something that is meticulously keeping track of details?
Because the nurses work for the doctors. That's why you pick the doctors, the nurses come along with them.
Couple of moments, Your Honor, please.
But in a hospital, you can. If you don't like your nurse, you ask for the charge nurse. They'll give you a different nurse. A lot of people don't realize that. You can always ask for a different nurse in the hospital.
And the last question, personalized service skills, what is that designed for?
Well, may I read the question he
Yes,
presented with?
Sure.
Okay.
Thank you.
Describe a time when you solved a difficult customer problem. You wanted to know what the situation was, what the problem was, what did you do to solve the problem, and what was the outcome?
Okay. And once again, customer includes patients?
Yes.
That's because the nurses do all the work.
And this is the last time I'm going to ask you this, and then I'm going to sit down, but would you consider giving a patient propofol without the authorization of a medical doctor, something that is designed to solve difficult customer problems?
No.
Okay. Thank you very much.
Redirect.
No redirect, Your Honor.
May this witness be excused. All right, thank you very much, ma'am. You're excused and you're released. Defense, you can call your next witness.
Does the defense rest at this time?
All right. Can you all approach?
My apologies, Your Honor. The last witness I would call would be Lieutenant Marshal Gatsby.
I thought they rested.
Raise your right hand.
You solemnly swear or affirm the testimony you're about to give will be the complete truth, so help you God.
I do.
Thank you.
Lieutenant, could you please state your name and spell your last name for the court reporter, please?
Marshall Gatsey, Gatzey.
Oh, he's just a baby.
And Lieutenant, how are you employed?
The Seminole County Sheriff's Office and the Correctional Facility.
And how long have you been employed with the Seminole County Sheriff's Department in the correctional facility?
14 years.
14.
Oh, he's
And
older than
do
he
you
looks.
know an individual by the name of Grant Amato?
I do.
And how do you know Mr. Amato?
I am a unit manager, the supervisor of the housing unit that he is an inmate incarcerated inside one of the prison facilities.
Is one of those units B-Pod where Mr. Amato has been housed?
Yes, sir.
Has he been housed there since his arrest on January 26, 2019?
For the most part of it, I believe he was initially on C-Pod for a short period of time, which is another area that I'm in charge of. But for the most part, he's been in B-Pod.
Okay. And do you see Mr. Amato in the courtroom here today?
I do. Yes, sir.
That's him?
Yes, sir.
All right. May the record reflect he's identified Mr.
You
Amato.
don't hate me.
Now, obviously, with 14 years working in the Department of Corrections, you've probably dealt with your
You don't
share of
hate me.
inmates who
You
are
like me.
have behavioral issues.
Yes, sir.
And what are some of those issues that you, the most common ones that you usually deal with?
Just disobeying facility rules, insolence towards staff, violent behavior, fighting amongst each other.
Now, when something like this happens, when an inmate breaks the rules, for example, say violent behavior in the jail, what is the usual response that correctional officers take in that regard?
They're written a disciplinary report, when moved to a segregated unit where they typically lose privileges in the facility.
Okay. And is another name for disciplinary report a DR?
Yes, sir.
All right.
Okay.
Now, there are other things that an inmate can do to earn disciplinary reports. Is that true?
Yes, sir.
All right. What are some of the other things that inmates can do to earn disciplinary reports besides an act of violence?
Possession of contraband items, insolence or disrespect to staff, violating majority of the facility rules as far as expected behavior.
And all of those things would generate a disciplinary report or a DR?
Depends on the severity. Some things start with a verbal counseling and progress into a disciplinary report if it continues.
Now, as the manager of B-Pod and C-Pod?
Yes, sir.
Okay. As a manager of B-Pod and C-Pod, do you have access to the records dealing with Grant Amato's stay at the Seminole County Jail?
Yes, sir.
And are you familiar with those records?
Yes, sir.
During the approximately 7 months that Grant Amato has been housed at the Seminole County Jail, has he ever gotten a disciplinary report?
No, sir.
Has he ever exhibited behavior that would make you consider him a management problem?
No, sir.
Would it be presumptuous of me to say that Mr. Amato, during the time period that he's been in jail, has been a model prisoner?
Yes, sir.
He has been?
He has been, yes, sir.
Okay. I don't have any other questions.
questions?
I have no questions.
All right. May this witness be excused and released?
Certainly may, thank you.
Okay, thank you, Lieutenant.
Well, then you don't hate nurse.
All right, now does the defense have any
Now,
further? All right. Yes, Mr. Lytle. All right. State, at this point, do you have any rebuttal?
We have we do, we like to call Christopher Cisco as a rebuttal witness. And we also have a statement which has been provided to the defense of Grant Amato in connection with the issue that he had in June of 2018.
Let's review, at this point, the statement can be entered at this time, and otherwise, before we have Christopher Amato, we'll take Christopher Cisco will take a recess. Do you wish to publish that to the jury?
No, I mean, it'll come into evidence and they'll have it available.
All right, so it'll be as State's Exhibit 1 at this time.
May I see?
Yeah.
Why is it so hard? I wasn't. All my patients love me.
All right, at this point, members of the jury, we're going to take a brief recess. We will finish everything today. We can also finish, we will be finishing closings. I can leave it up to you at this point. I'm going to let you all, while we're taking this recess, go back. I have intention of charging you and having you deliberate tonight if you choose to. And again, we'll stay as late as you want to, where you can get it over with today, or if you're able to. Otherwise, what if you do not wish to do it that way, we will come back tomorrow, and then I would charge you then, and you would start deliberating tomorrow. So that is entirely up to you all. So while we take that recess, I'll have you talk about it, and you can come back and let me know your decision.
You're in charge. Don't give them the chores.
All right. So we have the aspect of Mr. Cisco.
Yeah, they do. They do.
If we could proffer as far as what is Mr. Cisco?
They use the
intent
big
of
bag
his
needle.
testimony
Also
going to
use
be
the
at this
big
point?
bag needle.
Yes, Your Honor.
We use a teeny tiny needle.
It's rebuttal, and the reason being is that the defense has tried to portray Grant Amato as being a good student. This is evidence to simply show that that's not the case, at least in Mr. Cisco's experience, that he was kicked out of the nurse anesthetist school.
What does that have
That's
to do with
simply,
the death
purpose of
penalty?
putting, Mr. Cisco
Well,
on
he's
to
a bad
show,
student.
to rebut the evidence that Grant Amato was a good student, which is not the case.
All right. What do you
It was not the case.
What do you anticipate him testifying to?
That he was, there was, we can proffer his testimony if you like, but he was in school together, that Grant did not make it through the program. I think, I believe because he was sleeping on it. Right. I think Mr. Leo can probably,
What I was told, Judge, was that there were various instances where Mr. Amato was either sleeping in his car or indicating that he had provided breaks for other folks at the hospital and had not, and there was a pattern there, and that's what ended up having him removed from the clinical portion of the CRNA training, not the academic part, but the internship, as it were.
Okay. All right. Why don't we get Mr. Cisco in here and see what he's going to testify to?
proffer that?
Yes. I do note that on the original motion in limine from June 17th, 2019, that was filed by the defense, it was specifically referencing him, the defendant being dismissed from his graduate school was one of the things that was attempted, that the court had granted in regards to the guilt phase of the trial. So there was evidence prior to of him being dismissed from graduate school by either side. So we'll see where that goes. Come forward. You're still under oath, Mr. Cisco. All right. right, you may proceed.
Thank you, Lynn. Mr. Cisco, did you attend nurse anesthetist school with Grant Amato?
Yes, sir, I did.
And how long, tell the court the time period during which you were a student and Grant Amato was a student. In other words, the overlap that you and him participated in the program.
Sure. It would be January of 2015 is when we started the program officially, January. And then around the spring of 2016, I'd say March or April is when we no longer I didn't see him there in class anymore.
Okay, so a little over a year then.
Yes, sir. Mhm.
And was he dismissed or, for lack of a better expression, kicked out of the program?
Yes, he was.
And what were the reasons, your understanding, the reasons?
To my knowledge, while I was there at the hospital, it had happened over a course of a couple months where he would be given instructions to either be on the list to give breaks to other CRNAs or SRNAs that were there during the day. And when you're put on that list to give breaks, it's your responsibility to go throughout the operating rooms and give breaks to those that are in the operating room so that they can either eat, go to the restroom, whatnot, because they're not allowed to leave. There has to be an anesthesia provider there at all times. So if you need a break, somebody has to come relieve you. So it's his job to do that. Well, on multiple occasions, there were times where he was on breaks and he would be asked who he gave breaks to, and come to find out that that person had not got a break. And that on one occasion, he was found sleeping on a separate floor when he was supposed to be on breaks, giving breaks to those. And so he would be given, some kind of disciplinary action, and then it would happen again. On another occasion, he was sent as a student. It's our responsibility to go see patients that will be sent to the operating room later on in the day, and we would write a pre-op up for that patient. So it's not uncommon for a anesthesiologist to ask you to go see that patient on the floor, write up a pre-op before they come to the operating room. He would be gone for hours at a time doing pre-ops, and then that patient would come to the operating room, come to find out they were not seen by anybody from anesthesia when he was asked to do it. So not only would that not be done, but then he would lie about it. Did you go see this patient? Yes, I saw the patient, but clearly nobody had seen the patient. And so it takes quite a bit of disciplinary action for this to occur, but he was eventually dismissed from the program for clinical disciplinary action.
Okay, thank you.
In other words, not a rule follower.
Mr. Cisco, when did you bring all of this information that you've testified to the attention of the state attorney?
Actually, I believe I told the detective that came to my house the day after this all happened. So
do you remember which detective that was?
It's on a recorded statement. There were two detectives there. I don't remember exactly his name, but it's in a recorded statement that's provided. And so I did mention this to them after that. Mm-hmm.
Okay. And in your capacity as a student at Barry University, are you privy to the reasons a person is terminated from the program? I mean, where did you get this information? Did you see any school records or anything like that?
No school records, but word travels fast in the hospital.
Yeah.
Okay.
Yeah.
What I'm saying is have you seen any official school records from Barry that have demonstrated that what you've testified to today is the basis for Mr. Amato being terminated from the program at Barry?
I've not seen an official document, just word of mouth, sir.
Okay. And you made this detective aware of where these records could be found if they wanted to substantiate what it is that you're wanting to testify to here today?
Did I tell them that there were documents that they could find? No, I never mentioned that there were documents that they could find. I mentioned it to them that he was dismissed for the program around spring of 2016 for these reasons, is what I told them in a recorded statement.
And you told them where this school was located?
Correct, Barry University.
All right. And so how is it that you're sitting here now after my last witness testified about a resume? How is it that you're now sitting here telling us about what you believe Mr. Amato's reasons for being terminated from Barry was about? Why are you here? Who did you talk to? Which one of these gentlemen did you talk to? Sitting right here to my right.
I mean, we talked before we, maybe back in, I don't know when we first met.
Back when you told them this information back when y'all first met?
I believe I mentioned it to them, but I could be mistaken.
Uh-oh, discovery violation.
I don't have anything else, Judge.
No, I have no redirect.
Thank you, sir. You can step down and step out. Yes, Mr. Stone.
Your Honor, Section 921.141 subsection 1 specifically says that the rules of evidence in the penalty phase proceeding does not apply, and that hearsay is admissible provided the defense has a fair opportunity to rebut it. They had his recorded statement from day one, and they knew about it from day one. So they had more than a fair opportunity to rebut anything contained in that statement.
Response?
Well, Judge, I have not been on this case since January, but according to the trial counsel sitting right behind me, they said that they have never seen a recorded statement by Mr. Cisco provided by the state.
Yeah, Jill, that keeps happening. You
Do you
need
know
a
when
new
y'all
phone.
provided it?
Yes, we gave them everything. Maybe they didn't see it, but they got it.
Oh, calm down.
I think probably
Hello.
what I did was, at the very beginning of this case, I provided an inventory, I think. I haven't seen it, but I'm willing to wager Chris Cisco's statement is on that inventory. If the court looks at the very inception of this case back January, February, I specifically followed the pleading that used the word inventory. But they got it. I don't know if they've seen it or not, but they had it.
And Your Honor, I can help speed things along a little bit. The inventory was sent on April 10th, 2019. It's the following discs and flash drives contain discovery materials that have been provided to the defense. And about 5 entries down is interview with Christopher Cisco.
Bless you. It's on page 2. So,
As I said, I came on this date.
I
came on
understand.
this case back in June, so again, I'm just going on based on what I was told.
Based upon what's indicated, the inventory of the discovery materials disclosed indicates the interview with Christopher Cisco is there. And the court also notes there was a motion in limine regarding the dismissal of him being dismissed from the school. There was a motion in limine that was filed June 10th this year regarding any matters regarding that circumstance being excluded. So indicates that there was aware of the dismissal from the school based on the motion in limine, and the interview was provided according to this of April 10th, 2019.
I
So-
can't argue with what's there on the record, Your Honor.
And based upon the statute, hearsay is allowed to be used. So the court's
Yes,
going to
ma'am.
allow Mr. Cisco's testimony. All right. At this point, that would be a no. Are they ready? Okay. All right. I'll bring them back in. You may be seated. All right, State, you may call your next witness.
The state calls or recalls Christopher Cisco. Good afternoon, Mr. Cisco. Thank you, ma'am. Were you and Grant Amato in the students together or in the same nurse anesthetist program?
Yes, sir, we were.
And tell the jury the time frame in which both you and Grant Amato were in that program.
From January 2015 is when we started the program, and then around March to April of 2016 is when he was dismissed.
So just over a year or so, a little over a year.
Yes.
Tell the jury, please, the reasons why Grant Amato was dismissed from the program, to your knowledge.
Yes. So as students in the program, on occasion, we can be assigned to give breaks to other anesthesia providers in the operating rooms. So when we take a patient back to the operating room, there has to be an anesthesia provider in the room at all times. So if you are in a room that's 8 or 10 hours long, that requires that somebody come give you a break to eat lunch, go to the bathroom, whatnot. So when you are put on that list, you know in the morning that that's your job to give breaks. There were multiple occasions where he would be assigned to give breaks, and the appropriate marks would be put on the board that that person had a break, but then come to find out that person was not actually given a break at all that day, either for coffee or for lunch or for a bathroom break. And then there were times where instead of giving breaks, he was found like on a different floor taking a nap or sleeping instead of doing what was required of us as our job. On another occasion, we, again, as students, we are given the task or responsibility of seeing patients before they come to the operating room if they are in-house in the hospital. So an anesthesiologist will ask us, hey, can you go see a patient before they come down here to see if there's anything we need to do before they get down here? So you take a pre-op, you go see the patient, interview them, talk to them, then bring that back. And then that, that necessitates you seeing the patient before they get there. On multiple occasions, he was given that task. He would say that he went to go do that task, and then when the patient gets there, come to find out no anesthesia provider saw that patient at all before they got down there. And so not only would he not do it, but then when asked if he did it, then he would lie about whether he gave a break or whether he saw that patient before they came down here. And so when you're dismissed from a program, it's not like it's just a one-time thing. It goes to first where you are, or in Orlando, you get disciplinary action there. And then if you keep, doing the same offense, then it escalates, and then you get another disciplinary action, so on and so forth. Then eventually, once enough of those accumulate, then you are dismissed from the program for disciplinary action rather than academically.
Any questions?
Mr. Cisco, this information that you're testifying to here today, is this information that you got from officials at Barry University? Were you told specifically by them that this is why Grant Amato was dismissed from the program?
Yes, by word of mouth from either the anesthesiologist that was on that day or other providers that worked that day. Yeah. So by
That
word
day?
of mouth. Yeah. By word of mouth. Yeah.
That day? Are you talking about a specific day or a bunch of days?
Or, different providers on the days that such offenses occurred.
I see.
Multiple days, not one day.
Did you ever not get to take a break because Mr. Amato did not show up for you to relieve you for a break?
Not for me personally, but on the day I was there, yes, that's how I heard about it.
That's how you heard about it?
Yeah, by word of mouth.
Okay. So basically what we're talking about are rumors. You don't have any official documents or anything showing what the basis is for Grant Amato being dismissed from school. This is just what everybody was talking about.
What everybody was talking about, no, I have not seen any official documentation, but he was dismissed from the program in 2016.
Okay. No argument there. I'm just saying this is your version as to why he was dismissed.
It's not my version. It's the version that, we hear about, that by word travels fast in the hospital. So there's no secrets in the hospital.
Okay.
You do something, everybody knows about it.
Okay. All right.
Right.
Thank you. No further questions.
He is absolutely right.
Any question, any
No,
redirect?
I have no questions.
All right, may this witness be excused and released? All right, you may. All right. Members of the jury have just asking, have you decided whether you're going to go through for tonight? You're going straight? Okay. All right, so everybody is shaking their head no. Can I have like a consensus of actual verbal answers?
Yes.
Thank you. All right. So at this point, then what we're going to do is we're going to, I assume there's no more rebuttal from the state. Then we're going to end up going into closing arguments. Do you all, I realize we just took, I can give you a few minute recess, but then other than that, we're going to go right in. You may. Then otherwise, we're going to start closings. Okay?
She would strongly urge the trial courts at the request of the defendants include the mitigators in the jury's finding on the mitigators, especially in light of Hearst. That's in the rules that you're reading.
Understood. I also noted that it was contrary to the majority. I read her portion as well as Labarge's and Quinn's. All right. Here you all go. Here are the two sets of the jury instructions. Here's also what the court had indicated, which are placing the mitigators in the number order that they otherwise would have been listed, on the verdict form. All right. At this point, the court is going to get the jury and instruct them on the closing arguments. Are you still at 45 minutes each? Do you each think?
I think so.
Mr. Leichel?
Yes, ma'am.
Okay. And do you want a time frame that you want me to stop you, Mr. Stone, for rebuttal?
Well, there is no rebuttal.
Oh, yes, I'm sorry. You're right.
I'm thinking,
Are you going to be less than 40 minutes?
well, no, I'm kind of thinking, I don't want to cut myself too short. I'm thinking maybe an hour, but I won't be an hour. But I don't want to start rushing towards the end.
Why don't we try for 45 minutes?
Thank you. Welcome to the chaos. Yay, we have a new member. Everybody welcome a werewolf.
You're welcome. You may be seated. Members of the jury, both the state and the defendant have now rested their case. Their attorneys will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in your understanding of the case. Each side will have equal time. The state will go first and then the defense. Mr. Stone, you may proceed.
Thank you. Judge, you have the laser pointer. Yeah, can I use that one, please? No. Thank you very much. I figured out how to use it. Here, I'll show you. Multiple buttons. Well, thank you very much. We all thank you for the attention that you've given this case. And we're almost done. The judge is going to give you a very detailed set of jury instructions when you go back and deliberate. And you'll have a written set of instructions to take back with you. As a matter of fact, each one of you will have a written set of instructions to use and to refer to, because it can get a little confusing if you don't have the written set of instructions. And what I'm going to start out with is try to describe, and I'm kind of going to pattern myself off of what the judge will be instructing you on, and also the written instructions that you'll get. I'm going to try to go through the process that you need to go through in order to impose the death penalty, and it's multiple steps. Once again, all set forth in the jury instructions. But in order to impose the death penalty, you must, number one, unanimously find beyond a reasonable doubt that at least one aggravating factor has been established by the prosecution, by the state. That's the first step. If you do that, if the answer is yes, then the second step is you have to unanimously find that the aggravating factor or factors that you found established are sufficient to justify the death penalty. Once again, this is all going to be set out in the written instructions. That's step two. If those two steps, if the answer is yes to those first two steps, then you must determine whether any proposed mitigation that was put forward by the defense has been proven by the greater weight of the evidence. The judge will instruct you what that means, the greater weight of the evidence, going to be in the written instructions. And with regard to that particular finding, the jury need not be unanimous in finding that particular mitigating circumstances. It's an individual decision that each juror makes on his or her own. Then, after reviewing and considering the mitigating evidence, and if you find that any mitigating evidence has been established by the greater weight of the evidence, there's a fourth step. And the fourth step is you then must determine whether the aggravating factor or factors that you find exist outweigh the mitigating circumstances you find proven. Now, as I will talk about in a few moments, and as has been repeated to you many times, it's not simply a mathematical calculation, and that's something that cannot be impressed upon you more. It is not simply a mathematical calculation. There are going to be numerous mitigating circumstances that have been put forward to you and that are going to be argued. And I'm going to talk a little bit later on whether or not it's within your authority to simply reject a proposed mitigating circumstance. And the answer is yes, but I'm going to talk about that a little bit later. And of course, it's a two-way street. You can reject outright an aggravating circumstance that's been put forward to you. But the point is, it's not a mathematical process where you just simply come up with a number regarding the mitigating circumstances, come up with a number regarding the aggravating factors, and then, well, more aggravating factors than mitigators or more mitigators than aggravators. The one who has the most numbers wins. It's not that type of process. It's the quality of the factors that are presented to you. And once again, I know I've said it several times, you've heard it several times, but that cannot be overemphasized. It's the quality of the factors. And then finally, the fifth step, if you unanimously find beyond a reasonable doubt the existence of one aggravating factor, that aggravating factor or factors justify the death penalty, and that aggravating factor or factors outweigh any mitigating circumstances that have been proven to you, after all of that, then the fifth step is the actual decision that's recommended or given to the judge, whether it be the death penalty or life in prison without the possibility of parole. So I know it's a mouthful and it's a lot. And as I said already a number of times, you're going to have written instructions that specify in detail the process that you go through while you do your deliberations. So, what are the aggravating factors that have been put forward and proven to you beyond a reasonable doubt? Well, the first aggravating factor is that the murders were committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Now, the judge is going to give you an instruction on that particular aggravating factor. And in that instruction, the judge is going to define certain words contained within that aggravating factor. And the first is cold. The judge is going to instruct you that cold means the murder was the product of calm and cool reflection. I want to talk about that. I'm going to talk about the others also, calculated and premeditated. The murder was the product of calm and cool reflection. Let's talk about the evidence. And now I'm going back to the evidence in the first portion of the trial, the phase one of the trial. By his own admission, the defendant was with his mother all day. That's in the interview that he gave to Investigator Anderson and Investigator Multari. By his own admission, he was with his mother all day. Sometime in the very late afternoon, and we know that the last human activity on Margaret's computer was at 4:44 p.m., the defendant executes his mother by shooting her once through the head. From the time he murders his mother, the defendant waits for his father to arrive home from work at approximately 5:30, a little bit after 5:30, During that time, the defendant's mother is sitting face down dead at her computer desk. After his father arrives home from work, and while he's in the kitchen with his back to the defendant coldly walks up from behind and shoots Chad, his father, once in the back of the side of the head, immediately incapacitating him. Chad then falls down to the floor, but still alive, obviously, because you can see from those photographs that he crawls around the island that's in the kitchen. And while face down, the defendant then executes his father with a second bullet. He shoots him right through the head. For over 4 hours, with the body of his dead mother and father in the house, the defendant waits for Cody to come home. When Cody comes home, he arrives home at around 10 p.m. And while he walks through the threshold of the door that leads from the garage into the house, the defendant executes, and that's the word, executes, Cody with one shot to the face that goes through his head, immediately killing him. By any definition of the word cold, these murders were cold. By the definition that of the word cold that Judge Rex Siedler will give to you, these murders were the product of a calm and cool reflection. Once again, that's the definition that the judge is going to give you with respect to the word cold. The product of calm and cool reflection. Calculated. Well, the judge is going to instruct you that calculated means having a careful plan or prearranged design to commit murder. That's the definition that the judge is going to instruct you. The definition of the word calculated. What the defendant did in this case is he wanted to, and effectively did, stage a murder-suicide. There is no question that he planted those 4 shell casings, and he planted that gun near Cody's body. The shell casings matched the gun, once again, the gun near Cody's body, but the bullets were absolutely excluded from having been shot from that gun, which means the defendant had to have fired that gun, Cody's gun, 4 times at a time other than the murders. Remember the testimony of Jennifer Sawyer? One of the last witnesses to testify, her testimony was that she heard multiple shots in succession the evening of January 24th, 2019. And my recollection of her testimony was that it was later in the evening, around 8:30, I think between 8:30 and 9:30 she testified, which would have been at a time that was after Margaret and Chad's death, but before Cody's arrival and his death. You remember her testimony? So he had to have planted those bullets, and he had to have shot those shell casings, and he had to have shot Cody's gun at a time other than those murders. Then he picks up those 4 shell casings, and then with a gun other than Cody's, once again, the gun that was found near Cody, he kills his mother, his father, and his brother. Then he plants those 4 shell casings from Cody's gun, and he places Cody's gun near Cody's body. Once again, this all goes to the calculated part of the cold, calculated, and premeditated. And to complete the staged murder-suicide, to give the appearance of some kind of confrontation between an armed Cody and an armed Chad, he rolls Chad over on his back, and he placed that holster on Chad's right hip. We know that the defendant rolled Chad over on his back because the second shot was to the back of Chad's head. And that certainly was the fatal shot, which means that Chad could not have rolled over by himself. And we know that he was face down when he was shot, he, meaning Chad, shot in the back of the head because the entry wound of that bullet in the back of the head, the entry wound was the wound to the back of his head. And we know that there was the impression on that tile that was found, that was identified a few feet, a foot or two or whatever, to the right as you look at Chad's body, to the right of his body. So we know that bullet went through his head into that tile and they recovered that bullet. So we know that he was face down when he was shot and when he died. So he was rolled over. Unquestionably, he was rolled over. And additionally, the evidence clearly shows that Chad was right-handed and would never have placed that holster in the reversed position on his right hip. Do you remember that? That holster was not in the position it would be for a right-handed person. It was reversed. Once again, by any definition of the word calculated, these murders were calculated. By the definition of the word calculated that the judge will give you, these murders were the result of a careful plan or prearranged design to commit murder. Premeditated. Once again, cold, calculated, and premeditated. Well, premeditated is the judge will instruct you, is the same definition that you were given during the first part of the trial. And I'm going to put it up on the overhead now. But there's also one additional requirement that makes this type of premeditation part of the cold, calculated, and premeditated aggravating factor. But let me put something up on the overhead and talk about it. Now you see something else when I put on the overhead. Something else is highlighted. I'm going to talk about that highlighted portion with regard to the next aggravating factor that we'll discuss. But first, now I want to talk about the premeditated prong of the cold, calculated, and premeditated aggravating factor. This is the definition of premeditated, and that's what was given to you during the first part of the trial. And you'll see, a killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection. The premeditated intent to kill must be found before the killing. This is the second part of the definition of the premeditated prong. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A substantial period of reflection. That's the thing that makes what I'd call the regular definition of premeditated into the premeditated prong of the cold, calculated, and premeditated aggravating factor, a substantial period of reflection. Well, he had all day to think about and reflect on murdering his mother. Once again, Grant Amato admitted in his interview with investigators Anderson and Malteri that he was home with his mother all day the day he murdered her. She was murdered in the very late afternoon. Once again, we know the last human activity on that computer was 4:44 p.m. So she was murdered before Chad got home, very late in the afternoon. So the defendant had hours upon hours upon hours to reflect on murdering his mother, and he decided to do so. With regard to Chad, his father, the time between murdering his mother and murdering his father was approximately less than an hour. I mean, the evidence shows if we establish the time of killing of Margaret sometime in the very late afternoon, 4:45 to 5 p.m., and Chad arrived home just after 5:30, we're talking a time period of 40 to 30 minutes that he had to reflect, which is certainly a substantial amount of time to reflect and think about murdering his father when he arrives at home. But there's also one other thing I would like you to remember about this case, that there's certainly evidence in this case from which you can find that these murders were pre-planned and designed well before January 24th, 2019. Such as the planting of the evidence, namely Cody's gun, the shell casings, and that holster that was found on Chad's hip. His all-consuming obsession with that woman in Bulgaria, Sylvie. His absolute contempt for his family by ending his relationship with Sylvie, which was tantamount to ending his world as he believed it to be. All of this as demonstrated in that letter that he wrote to his chat room companions, which is in evidence and certainly you can refer to during this part of the trial. Once again, the evidence in the first part of the trial as it pertains to aggravating and mitigating circumstances is certainly something you can review and consider. So I ask you, when you consider about the premeditated part of this case, look back at that letter and then ask yourselves, are the seeds then being planted for what he did? And you'll see from that letter his absolute obsession with this woman and his absolute contempt for his family for ending his world as he believed it to be by terminating his relationship with Sylvie and revealing to this woman who he really was. That certainly allows you to infer and certainly gives you the basis to plausibly find that this was something that was conceived well before January 24th, 2019. With respect to Cody, it was over 4 hours. Remember, Cody arrived home sometime around 10 p.m. It was over 4 hours from the time that he murdered his father to the time that he literally lay in wait and murdered Cody as Cody walked through that door. Over 4 hours. And is there any question that he was thinking about doing, what he was thinking about doing, what he was reflecting on the second Cody walked through that door? Is there any question about that? What does the evidence show you? That Cody was shot the second he walked through that door. And you remember the testimony of Christine Snyder where she said that she actually stood by that wall and she smelled gunpowder? Do you remember that testimony? That was the wall this is the wall and this is the door from the garage into the house. And Christine Snyder's testimony was that she smelled gunpowder over there. So is there any question that he was waiting for the second that his brother Cody walked through that door, and the second he walked through that door, shot him right in the eye? The last thing that Cody saw probably, with the bullet going right underneath his eye, was his brother killing him. And once again, as I just noted a couple of moments ago, there is certainly evidence that allows you to conclude that these murders were planned and thought about well before January 24th, 2019. And finally, with respect to this particular aggravating factor, the murders must be without a pretense of moral or legal justification. That's the very bottom paragraph here. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, and premeditated nature of the murder. Well, what is that? What is a pretense of moral or legal justification? Well, let me give you just a couple of examples, and then hopefully the point will be made. Classic examples of a pretense of moral or legal justification are that a murder was committed to end the life of a person, usually a family member, who was terminally ill or suffering, or a person, almost always a woman, who has been physically abused and kills her abuser. Those are murders, and they could very well be first-degree murders. But there is certainly, in those instances, a claim of a pretense of a moral or legal justification that would disqualify it from being a cold, calculated, and premeditated aggravating factor. None of that exists in this case. There is nothing remotely to suggest that the defendant committed these murders with a pretense of a moral or legal justification. Absolutely nothing. The second aggravating factor in this case is that Grant Amato was previously convicted of a capital felony. Now, the judge is going to instruct you, and let me put that portion of the instruction on the overhead. That first of all, the crime of first-degree murder is a capital felony, obviously. That a prior violent felony aggravator includes violent felony convictions resulting from crimes committed on separate victims during a single criminal episode. For each individual conviction of first-degree premeditated murder, you may consider the other two convictions as previous convictions of another capital felony. The judge will instruct you to that effect. The judge will instruct you that the prior violent felony aggravator includes violent felony convictions resulting from crimes committed on separate victims during a single criminal episode. The events that occurred at 2112 Sultan Circle, starting the afternoon of January 24th, 2019, and ending the early morning hours of January 25th, 2019, during which the defendant murdered his family, is a single criminal episode. With respect to the defendant's conviction for first-degree premeditated murder of his mother, you may consider his convictions for the murders of his father and Cody as previous convictions of another capital felony. With respect to the defendant's conviction for the first-degree murder of his father, you may consider his convictions for the murders of his mother and Cody as previous convictions of another capital felony. And with respect to the defendant's convictions for the first-degree murder of his brother Cody, you may consider the convictions for the murders of his mother and father as previous convictions of a capital or for a capital felony. And remember, those previous violent felony convictions are for the crime of first-degree premeditated murder, a capital felony, a fact that makes them much more weighty. They are not convictions for other types of violent felonies, such as aggravated battery or armed robbery or other forms of murder, which are, of course, serious, but not nearly as serious as first-degree premeditated murder, which is a capital offense. Now, once again, it cannot be emphasized that the process is not simply a numerical process, it's the quality. It's not just simply adding up the number of aggravators versus the number of mitigating circumstances, because I expect you're going to hear argument and proffered evidence regarding numerous mitigating circumstances. Some are called statutory mitigating circumstances. Two of those statutory mitigating circumstances are that the defendant had no prior significant history of criminal activity, the other being the age of the defendant at the time that he murdered his family. He was 29 years old, by the way. And there are what are called non-statutory mitigating circumstances. I expect you're going to hear numerous alleged non-statutory mitigating circumstances. And that's basically any aspect of the defendant's background, character, that you may feel may militate against the imposition of the death penalty in favor of the life in prison. But it's the quality of the aggravating and mitigating factors and circumstances that you are to consider. And if you find exist, you weigh against one another. And please remember, please note that I said, if you find exist. And what I mean by that is evidence of aggravating and mitigating circumstances have been presented for your consideration. And of course, just like any other item of evidence, you need to consider it. But considering it doesn't mean that you accept it. It's completely within your authority, after considering it, to absolutely reject it or to give it minimal weight. That's completely within your province and authority. Now, the evidence in this case, with regard to the two aggravating factors, has been established clearly beyond and to the exclusion of any reasonable doubt. And they are very weighty aggravating factors. Cold, calculated, and premeditated, and then previous convictions for a capital felony. These are two significant and heavy aggravating factors. We're talking about a triple murder. Clearly, the law allows those two aggravating factors in and of themselves to justify the death penalty. Now, against those aggravating factors, you must weigh the mitigating circumstances that you find to exist. And I want to talk about just a few of the mitigating circumstances that have been put forward to you. First of all, there's the statutory mitigator that is alleged that the defendant has no significant criminal history. Well, in assigning that any weight, and you can assign it no weight at all if you choose to, I want to make a couple of observations. no significant criminal history. Well, once again, you can consider the evidence that was presented to you during the first part of this trial. The hundreds of thousands of dollars that was taken from his family to continue that online relationship with the Bulgarian, with Sylvie. That's something that you may consider. And you don't need to have convictions in order for you to consider whether or not the aggravating factor of no significant criminal history has been negated. It's not necessary that the state put forward to you, well, he was convicted of this and convicted of that and convicted of this. Evidence of criminal activity is sufficient to rebut or negate that particular statutory mitigating circumstance. Think of all of the money that he literally took and stole from his family to continue the online relationship with Sylvie. That's something that you may consider when you assign what weight, if any, you give to the no prior significant criminal history mitigating circumstance. What about the taking of that propofol? You heard evidence about that without authorization and without a medical doctor's prescription or authorization. He would give it to patients. You can consider that when you consider whether or not you should give any weight to the statutory mitigating circumstance that's been put forward to you of no significant criminal history. The other statutory mitigator that's been presented to you is his age. Keep in mind, he was an adult when he committed these murders. He was 29 years old, going on 30. He wasn't 18, he wasn't 19, he wasn't 20 years old. He'd already graduated school, he already graduated college. He was working on postgraduate work. He was an adult when these crimes were committed. He was 29 years old. Wasn't a kid. There are going to be significant non-statutory mitigating circumstances that are presented to you, and I expect that you're going to see a list, one list after another. And you look at that list very, very carefully. No history of prior violent behavior. Grant Amato had no history of early violent behavior. He has the ability to adjust to structure. No history of substance abuse or alcohol abuse. Grant Amato has no history of brain or neurological impairment. Grant Amato does not have an antisocial personality disorder, and he's not a psychopath, and several others. Basically, and that's pretty much based upon the testimony of Dr. Carpenter. Basically, what that's saying is he's a normal person. He's a normal person. When you boil it down, that's what those non-statutory aggravated mitigating circumstances say. He's a normal human being. Decide whether or not you want to assign that any weight as a mitigating circumstance. A normal human being that killed his family, that killed his mother, father, and brother. Now, I just have a couple of final remarks that I want to make to you, then I'll sit down and Mr. Like will have a chance to make his argument. First, you'll be given a jury form, and I was going to go over it with you, but it's pretty self-explanatory, but I don't think I have enough time to do it. But it's pretty self-explanatory. It just goes through that those particular 5 choices, those 5 questions that are presented to you. And for each, for Margaret, Chad, and Cody, you'll have a separate verdict form to decide what the appropriate punishment is. But let me just close out with this. When you go back to the jury room, please consider all the evidence, as you should. Please consider all the mitigating circumstances that have been presented to you, keeping in mind that it's fully within your province to reject and give no weight to the defense's proposed mitigation, finding that they're not truly of a mitigating nature. And also remember this. Remember that you're never required to vote for the death penalty. You're never required to do that. But the issue is not whether or not you're required to vote for the death penalty. The issue is whether you should vote for the death penalty because it's the appropriate sentence. And when you consider that question, whether you should vote for the death penalty because it's the appropriate sentence, please consider the enormity of the crimes the defendant committed. Consider the enormity of what he did. The judge will instruct you that you must carefully consider and weigh all the evidence, realizing that a human life is at stake. Well, when you think that a human life is at stake, depending upon your vote, once again, please think of the enormity of what this defendant did. His mother, his father, and his brother. Just think about that. And when you're confronted with the reality that it is indeed hard to vote for the death penalty, please think of the overwhelming, mind-boggling enormity of what this defendant did. With the exception of Jason, he murdered his entire family. Just think about that. I say this respectfully. Every single one of you said that you can vote for the death penalty in the appropriate case. Every single one of you said that. If there was ever an appropriate case, this is the one. Thank you.
Mr. Leichel,
I need just a moment to set up a computer.
go right ahead.
Take this down.
And if there's anything you're going to want to put on the overhead, I can switch it over if you need to. You're welcome. You may proceed.
Ladies and gentlemen, I want to thank all of you for all the hard work and for sticking with us here today. We're almost at the 5 o'clock hour. So I want to start my closing argument by addressing Mr. Stone's arguments in reference to these aggravators. With regards to the prior violent felony, where the instruction clearly shows that you can use violent acts that are committed during a single criminal episode, case law says that he can make that argument. But ladies and gentlemen, it seems like Mr. Stone is sitting here arguing the enormity of this horrible thing that happened. And believe me, it was a horrible thing that happened. It was. And he wants to use all three of those murders as a justification for y'all to enter the death penalty. But he also wants you to count them as separate and apart. It seems as if the state is wanting to eat its cake, wanting two bites at the apple. It's basically what they're looking for. Now, When it comes to the cold, calculated, and premeditated aggravator, I don't believe I heard Dr. Carpenter say one time that what Mr. Amato stands convicted of doing is something that a normal person would do. The whole purpose of Dr. Carpenter's testimony was to try and provide you with the information that says Grant Amato will make a fine adjustment to the structure of a life sentence in prison. That is the only reason that Dr. Carpenter testified here today. He did not testify about him being a normal person. All of the factors associated with the lack of a prior criminal history, the no early crimes of violence or all of those things, all of those were factors that went into his professional opinion that if you decide Mr. Amato should serve the rest of his life in prison without ever coming out, that he would be able to do it, and that within that structure of prison, based on his time at the Seminole County Jail, he will not present a risk of danger to either inmates or staff. That's all that was. I'm not trying to make it anything more than that. Now, with this cold, calculated, and premeditated aggravator, remember the state's evidence of a timeline is all theoretical. I mean, the murder was committed by a gun that's represented by a picture. Their theory that Miss Amato was shot at 4:44 p.m. is based on the premise that she was not using her computer anymore and was sitting at her computer desk. I'm not going to sit here and belabor the conflicts that existed in that evidence. I told all of you that we respect the verdict in your case, and I'm not going to go back and rehash it. I will let you draw your own conclusions. Now, I want to talk about the individual aspect of what you are all about to go do after you get the final instructions from Judge Rex Siegler. No juror is ever required to vote for death. Not in this case, not even in the worst case you can imagine. Mitigation is any reason to choose life or to not choose death. The mitigation that we're presenting to you today, Mr. Stone went over our list that we'll be going back with you briefly. It's just a list. How much weight you assign to it is totally up to you. Mitigation, ladies and gentlemen, make no mistake, we're not coming in here and saying that mitigation is in any way, shape, or form an excuse for what happened. It is merely to assist you in coming to the right sentence. It certainly doesn't have to be connected in any way to this crime. Mitigation comes from each of your own individual backgrounds, experiences, and yes, most importantly, your sense of mercy. All of us have it. How much you decide you want to apply to this particular case is up to you. You know, you can even come up with your own reasons for choosing life. Nobody says it has to come from this list or that list. You all come in here as unique individuals being charged with a very weighty decision. And you know, something can be mitigating and you can't even put it into words. It's just a feeling that you have. It doesn't have to be something specific. It's based on your own life experience. Each juror can give the weight of life to any one mitigating factor, including mercy. You alone as individuals get to assign the weight or significance to any mitigating circumstance. And something that's very important, it doesn't have to be unanimous. Remember, I told you unanimity was something that only applied in the guilt phase. It does not apply in a penalty phase. And you know what? You can use whatever mitigating circumstance leads you to vote for life, even if the rest of the jurors disagree with you. This is not about peer pressure here, ladies and gentlemen. This is about coming to your own decision. You can certainly find that one mitigating circumstance from the 16 that we'll be providing you outweighs the aggravating circumstances raised by the state. This is an individualized moral decision, not a group factual decision. The group factual decision happened in the guilt phase, not in this one, not in the penalty phase. One juror may feel very strongly that life is appropriate, and another juror may disagree with that person. It's perfectly okay. Doesn't mean that you're right and he's wrong, or he's right and you're wrong. Remember what I told you in my opening statements. If it's your decision, it's the right decision, whether you agree or disagree with another juror or not. And the other thing is, no one has to justify, explain, or to put into words their reason for his or her vote. However you vote, that's your vote. Nobody's going to tell you why you're wrong or why you're right, because if they're doing that, then they're not following the instructions when it comes to how jurors should conduct themselves in that room. All of you have spent a lot of time together over the last month. You need to treat each other with respect. And you know, it's not really appropriate to demand that somebody believe the way you believe. Which brings me to my next point. Every juror has the right to be treated with dignity and respect. No juror should ever be coerced, intimidated, or treated unprofessionally. You ladies and gentlemen have conducted yourselves professionally throughout this entire trial. Now is not the time to stop. Every one of you sitting here today is qualified to sit on this jury. Every one of you is a valued member of this jury. In this country, we respect the right of people to have their own value system. And we don't try and impose our values on
Do we? Do we really?
So when you go back in to deliberate, please
We're supposed
be
to.
respectful of each other.
Doesn't always work out that way, though.
One vote for a life sentence without the possibility of parole is not a hung jury. There's no such thing as a hung jury in a penalty phase. Just can't happen. That only happens in the guilt phase, where you couldn't come to a unanimous verdict, where somebody is holding out and will not make up their mind and will not agree with the majority of the jurors and will not change their vote no matter how long you deliberate. And that's when a mistrial is declared and the whole process starts over. We're way past that point now. Life in prison without the possibility of parole means exactly what it says. Grant Amato will die in prison. He will never get out. He will never qualify for parole. He'll never qualify for work release. You heard Dr. Carpenter talk about he'll start out in a maximum security prison until they've determined at what level prison that he can be reassigned to. But ladies and gentlemen, people that are convicted of murder, premeditated, they don't get minimum security prisons. Now, if you vote for life, remember, you're not going to be hanging up the jury. You're not going to be taking the vote hostage. You're not going to be a holdout. You're voting your own specific way. A non-unanimous vote on punishment is legitimate and lawful, just like I told you. If one juror votes one way and one juror votes the other way, they're both right. Nobody's wrong. Each juror has a legal duty to get his or her decision onto the verdict form and into court. What do I mean by that? What I mean by that is the law says you must not sacrifice your individual moral judgment and decisions just for the sake of agreeing with other jurors because you're outnumbered. Okay? You have the right, the duty, and the obligation to stick by your decision, even if the majority of jurors is against you. Do you remember in voir dire, just about every one of the individual voir dire questions, Mr. Dowdy asked you, if it comes down to it, and you want to vote life and nobody is agreeing with you, will you knock on that door and say, hey, I'm done. I've carefully considered and I'm done. Let me out. I vote for life. That's it. It's done. It's over. Finally, number 10, the law is always satisfied with a life vote and is never satisfied with a coerced vote. You stand your ground. If the final vote includes a life vote, you have successfully discharged your duties as a jury. That means the process has worked. Now, the mitigators, the judge is going to be giving you a list of the mitigators that we are going to be sending back with you. Now, there are 16 of them on the list. The first two are statutory mitigators. No significant history of prior criminal activity. Ma'am? Yes, ma'am.
Stealing drugs isn't criminal activity. Sounds like criminal activity to me. Stealing. But I guess they didn't prosecute him. so it doesn't count.
I'm sorry, I misspoke. I have a list of 16 mitigators. I guess I'm going to ask you all to write them down so that you can remember them and assign them the weight that you would like to do that. The first mitigator is no significant history of prior criminal activity. That applies to Grant Amato's history before his arrest for the charges and the crimes in this case. Now, Mr. Stone wants to make a crime out of the fact that Grant Amato took money from his family, which, if anyone in his family had decided to press charges against him, had signed a sworn criminal complaint against him, had provided it to law enforcement, charges had been filed, I might agree with him. But the Amato family had gotten past all of that. They were trying to work with Grant Amato about that money. Remember, it was discovered long before these murders occurred. So I'm not seeing it as far as prior criminal history goes there. The other one is the fact that he was arrested in reference to this propofol. Well, ladies and gentlemen, you heard, and you will be taking back the no information that was filed by the Orange County State Attorney's Office, which states, I quote, "From the investigation which has been made, it is the opinion of the writer, Catherine A. Marlowe, Assistant State Attorney, that this case is not suitable for prosecution." I don't care if he was arrested or not. The state decided not to file charges. So until his arrest in this case, he had no prior criminal history. And I believe we've proven that mitigator by the greater weight of the evidence. Now, the mitigator that Grant Amato was 29 years of age at the time of his crime. The reason I believe that's significant is because Dr. Carpenter told you the significance. That being Grant Amato's ability to go into the structure of a prison setting without causing any problems. That's the significance. That's the significance of that. Well, thank you. Get some help here. Lack of prior criminal convictions. Before this case, Grant Amato had no prior criminal convictions. Y'all can probably write this faster than I can say it. Grant Amato had no history of violent behavior. Those would be reflected in the school records here that you'll be taking back to the jury room. If you look at his school history records, at least elementary, high school, there's no behavioral problems there. And during the period that Mr. Amato has been in the Seminole County Jail, he's had no disciplinary reports. Lieutenant Gatsey, he testified to that. That one's established by the greater weight of the evidence. And that he has the ability to adjust to structure. He has certainly shown that, since for the very first time in his life, he spent over 7 months in a county jail. He's been a model prisoner. No disciplinary reports. Has no history of substance abuse or alcohol abuse. Ladies and gentlemen, I can tell you that those who are charged with supervising people in the medical profession take it very seriously. We don't want people who are providing medical care for us to be impaired in any way, or even there be a suspicion of it. My question to Dr. Carpenter, I asked him if he was familiar with the Physicians Recovery Network, or PRN, which is that administrative body charged with overseeing individuals if there's even a suspicion, so that Had Grant Amato not committed these crimes and had Grant Amato gotten that job with Express Scripts, there's probably the possibility that his critical care registered nurse license would have been under PRN supervision for a period of time. Remember,
No, he wouldn't have gotten that job.
there was a battery of toxicology tests taken to determine if there was any drugs whatsoever in Mr. Amato's system. The only thing that was there was an ETG, a metabolite, which basically indicates that at some point in time in the last day or two, or as Dr. Carpenter testified, that he had a beer with dinner the night before. Certainly no indication of alcohol abuse or anything like that. He has no DUIs. He has none of that. There's no identifiable mental illness or history of psychiatric treatment. True. Has no history of brain injury or neurological impairment. Also true. Does not have an antisocial personality disorder or psychopathy. Dr. Carpenter testified that those things are true and it's unrefuted. Grant Amato has no history of behavioral disruption in school records. There they are. You can see them yourselves. Grant Amato's bachelor's degree is in nursing, meaning that from whenever he decided what he wanted to become when he went to college, Grant Amato cared about caring for people. That was what his chosen profession was. And by all accounts, from the testimony of Jessica Bean, he did a very good job. Or as Dr. Carpenter stated, he's a caregiver. Grant Amato's good capacity for social relations in the community. Cody and Grant were part of a circle of friends. They'd been friends ever since they were in high school, all the way up to this point in time, years and years later. So Grant Amato has demonstrated his ability to exist within a social circle. And then number 15, of course, related right to Dr. Carpenter's testimony and evidence. Base rates of violence in prison are favorable to Grant Amato. You saw what those graphs showed you from the age of 30, how any potential problems go all the way down to nothing. And he's on that downward slope as we sit here today. And then again, number 16, any other mitigation that I haven't specified to you. For those of us who are technologically challenged. Okay, so
Now we're going to see pictures of him when he was a little boy.
what are we doing? At the time that Grant Amato committed these crimes for which he stands before you today, he had been on this earth a total of 362 months, which is 29 plus born on March of 1989. Comes to 362 months total that he'd been alive on this earth. What we're all here about is a 6-month time frame. A 6-month time frame from July 2018 when this relationship with Sylvie began. The one that Mr. Stone, by his own words, indicates to all of you, I don't know what you believe, but what Mr. Stone believes was an obsession, an addiction, something that consumed him, something that caused him to kill his family. This obsession, this addiction. We're talking 6 months out of 362. You know what that comes to? That comes to 1.68% of
He
his life.
killed his parents.
We're here deciding life or
I
death
don't care how much
based
of his
on
life it encompasses.
time period of 1.68%
God,
of his life. Less
are
than
you
2%.
kidding me?
As far as the other 98%, mitigating factors, we're asking you to consider Grant's life.
I think Jason has the same feeling about that
Here's
as
the
I do.
question.
Look at his face.
Grant Amato is either going to die by God's hand or the governor's hand. How he dies is determined by your own individual moral decisions. Please consider the 98%. I'm not even going to read these to you. You can read them yourselves.
I can't tell if
He
he
was
wants
born a
him
good
to get the
Catholic
death
boy.
penalty or not. I mean, he is his brother after all.
He was baptized on September 10th. Got his first communion in April. And as you can see, all of his grades are wonderful. All of his citizenship is wonderful. He was a Boy Scout. He was an outstanding student at Timber Creek High School. Member of the National Society of High School Scholars. Each of those sentences there, self-motivated, loyal, and dependable. Never a discipline problem. A particular affinity for science. All of those came from letters that were written to the University of Central Florida from his teachers and guidance counselors. Wrong.
I just had a Sarah Boone flashback. I don't think you understand who I am. I'm a straight A student. Sorry.
Those are the letters from which those quotes are taken. This is a personal statement. It's contained in the UCF records where Grant was asked to write
None of that matters if you murder somebody.
Attend UCF. And in it, one of the statements that he says, this is back in 2010, 2011, most influential person in my life is my father. Although my family supplies much of the unconditional love and understanding, it is certainly my father who taught by example how to set and reach goals. Remember, ladies and gentlemen, I told you that I'm not presenting this mitigation as an excuse. I'm trying to provide you with a glimpse into Grant Amato's life before the terrible tragedy that struck his family.
The terrible tragedy that struck his
He admired and
family.
loved his dad.
That's passive. That is not what happened.
He adored his mom.
I can't believe he just said it like that. The horrible tragedy that struck his family.
He was part of this circle of friends.
It's distancing language.
There was a time when Blake Turpin and Jericho Fine, they were all part of the same.
I had a 3.8 GPA in nursing school, and I won the Academic Excellence Award. You know what that gets me? That and $7 will buy me a cup of coffee, okay? That gets me nothing. Absolutely nothing.
That's them having dinner together. That's them.
Exactly.
They were part of a
And I'm going to
Airsoft
say
team.
it again. He hired a hitman from prison. I said I wasn't going to say it again, but I said it again. He hired a hitman.
Grant and Cody were always inseparable.
But they're separable now. Because he killed them.
Grant was a good friend to all of these people until this tragedy. But his best friend was Cody. And yes, just like Jason loves Grant, Grant loves Jason.
You, sir, are an idiot.
You remember the scene from the interview?
Just remember that. Just like Mom, Cody, and Dad loved you. Nobody loves you any more or any less. I'll pray for you, brother, so that you can't hurt the lost Dad and Cody anymore. See?
She is so pretty. I don't know what. I didn't say that out loud, did I? Did I just say that out loud?
Explanation, excuse, or anything else for what Grant Amato stands here accused of, convicted of, facing life or death. But just remember, that all happened in 1.68% of his life. I ask you to consider the mitigators that I presented to you today. I ask you to consider the 98% of Grant Amato's life where he was a good person, a good boy, a good son.
You mean where he stole drugs and gave them to patients that didn't have an order?
I also ask
That
each
good
of
boy?
you to remember that now is the time for each of you to make your own individual moral decision about what is best. I believe everything that's been presented here screams out for a life sentence. I ask you to return one. Thank you.
Members of the jury, you've heard all the evidence and argument of counsel. It is now your duty to make a decision as to the appropriate sentence that should be imposed upon the defendant for the crime of first-degree murder. There are two possible punishments. 1, life imprisonment without the possibility of parole, or death. In making your decision, you must first unanimously determine whether the aggravating factors alleged by the state have been proven beyond a reasonable doubt. An aggravating factor is a circumstance that increases the gravity of a crime or the harm to a victim. No facts other than proven aggravating factors may be considered in support of a death sentence. The aggravating factors alleged by the state are: 1, Grant Amato was previously convicted of another capital felony. The crime of first-degree premeditated murder is a capital felony. The, quote, prior violent felony, end quote, aggravator includes violent felony convictions resulting from the crimes committed on separate victims during a single
Okay, this is like 26 minutes long. Do you guys want to listen to the instructions or just go to verdict? I'm going to read you guys. Oh, where'd it go? There it is. This is the Nightingale Pledge. This is the Florence Nightingale Pledge. This is the pledge, like doctors take the Hippocratic Oath, nurses take the Florence Nightingale Pledge. This is what we say when we graduate. I solemnly pledge myself before God and in the presence of this assembly to pass my life in purity and to practice my profession faithfully. I will abstain from whatever is deleterious and mischievous and will not take or knowingly administer any harmful drug. I will do all in my power to maintain and elevate the standard of my profession and will hold in confidence all personal matters committed to my keeping and all family affairs coming to my knowledge in the practice of my calling. With loyalty will I endeavor to aid the physician in his work, and as a missioner of health, I will dedicate myself to devoted service to human welfare. So, we are not allowed to be mischievous or deleterious or take or knowingly administer any harmful drug. So I would say that he did not fulfill his oath. Uh-oh. Hang on. I can't get back to... Now I can get back to StreamYard. So that's the oath that we take when we graduate nursing school. Yeah, when I was a pediatric nurse, we had shenanigans and mischief. The kids taped our unit clerk to a chair one time. He actually sat there and let the kids tape him to a chair and then roll him around the floor. And he
All right,
had
I'm
long
told
hair
that the
too.
jury has reached a verdict.
Long hair.
Everyone's
And he
present,
taped his
so
hair.
let's go get the jury.
Like, Stuart, what are you doing? Why would you
And
have
just
to
to
do
let
that?
you know, there are again 2 questions, if they could have Post-it notes and if the AC could be up. Both of those are getting filed.
We'd have silly string fights.
Since they were, again, non-legal, non-factual, nothing to do with the case, those were handled.
Oh, we had fun. We had
You
a
may be
lot of
seated.
fun.
I'm told that you reached your verdict.
I can't figure out why Stuart
Please
let
hand
them
it to the
tape
deputy.
him to the chair, though.
Please publish the verdict. Mr. Amato, if you could please stand.
Count 1, Margaret Amato. We, the jury, find as follows as to Grant Amato in this case. A, aggravated factors as to count 1. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that Grant Amato was previously convicted of another capital felony. Yes. B, sufficiency of the aggravating factors as to count 1. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt, section A, we, the jury, unanimously find the aggravating factors are sufficient to warrant a possible sentence of death. Yes. C, mitigating circumstances. One or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. Yes. D, eligibility for the death penalty for count 1. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt, section A, outweigh the mitigating circumstances established, section C above, as to count 1. Yes. E, jury verdict as to the death penalty. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt, section A, that the aggravating factor or factors is or are sufficient to warrant a sentence of death, section B, and the aggravating factor or factors outweigh the mitigating circumstances, section D, we, the jury, unanimously find that Grant Amato should be sentenced to death. No.
No.
Count 2, Chad Amato. We, the jury, find as follows as to Grant Amato in this case. A, aggravating factors as to count 2. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that Grant Amato was previously convicted of another capital felony. Yes. B, sufficiency of the aggravating factors as to count 2. Reviewing the aggravated factors that we unanimously found to be established beyond a reasonable doubt, section A, we, the jury, unanimously find the aggravated factors are sufficient to warrant a possible sentence of death. Yes. C, mitigating circumstances. One or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. Yes. D, eligibility for the death penalty for count 2. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt, section A, outweigh the mitigating circumstances established, section C above, as to count 2. Yes. Jury verdict as to death penalty. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt, section A, that the aggravating factor or factors is or are sufficient to warrant a sentence of death, section B, and the aggravating factor or factors outweigh the mitigating circumstances, section D, we, the jury, unanimously find that Grant Amato should be sentenced to death. No. Count 3, Cody Amato. Aggravating factors as to count 3. We, the jury, find as follows as to Grant Amato in this case. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that Grant Amato was previously convicted of another capital felony. Yes. B, sufficiency of the aggravating factors as to count 3. Reviewing the aggravated factors that we unanimously found to be established beyond a reasonable doubt, section A, we, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible a sentence of death. Yes. Mitigating circumstances. One or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. Yes. D, eligibility for the death penalty for count 3. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt, section A, outweigh the mitigating circumstances established, section C above, as to count 3. Yes. Jury verdict as to death penalty. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt, Section A, that the aggravating factor or factors is or are sufficient to warrant a sentence of death, Section B, and the aggravating factor or factors outweigh the mitigating circumstances, Section D, we, the jury, unanimously find that Grant Amato should be sentenced to death. No. Signed, foreperson, dated August 12th, 2018 in Seminole County, Florida.
Do either of you wish to have the jury polled?
No.
Defense?
No, ma'am.
All right. Ladies and gentlemen, I wish to thank you for your time and consideration in this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We've recognized for hundreds of years that juries' deliberations, discussions, and votes should remain their own private affair as long as they wish it. Therefore, the law gives you the unique privilege not to speak about the jury's work. Although you are at liberty.
There's no reason to delay it, Your Honor. There's only one sentence that can be imposed.
All right. Mr. Amato, if you could please stand. All right. As to, and state at this point, any thing that the state wishes to address with the court prior to me sentencing Mr. Amato?
Just one thing, although it may be academic, there is an mandatory that needs to be imposed, 25 to life. So I just ask the court to just consider that in its sentencing.
All right. Based upon this case, 2019 CF 337 CFA, the state of Florida versus Grant Amato, you've been found guilty of 3 counts for killing both your mother, your father, and your brother, Margaret Amato, Chad Amato, and Cody Amato. At this point, you've been found guilty by a jury of your peers who have now indicated that you are not to be sentenced to the death penalty. Based upon those circumstances, the court is limited to 1 finding and 1 sentence for you. As to each count, the court would adjudicate you guilty. I would sentence you to life imprisonment without any possibility of parole as to each count. I further would indicate that you are to be released to the Department of Corrections as soon as feasibly possible. And otherwise, sir, just God have mercy on your soul. Nothing further at this point. Could give credit, but it would be not necessary. But what is the credit for time served?
Yeah.
It wouldn't have any effect on it since it's life without parole. All right. Anything further before the court adjourns? All right. Court's in recess.
Okay, we got another one done, y'all. Okay. Do you guys want to start on Murdaugh now, or do you want to wait till Friday? Because I'm going to be out of town tomorrow. Because I have people coming out of town to visit. Because what time is it? It's still early, right? Yeah. I had set it to start at 3 because I thought we'd be longer on this, but tell me, people, what are we doing? Are we done for the day? Or are we doing Murdaugh? Starting Murdaugh. Somebody decide. Up to me. Okay. All right, I gotta start a new stream. I'll start a new stream. We'll start Murdaugh. Okay, I'll see you over there. I didn't set it to redirect, so you'll have to find it. I forgot. Okay, see you over there in a minute.